Good afternoon, all. This appeal hearing is in the matter of CA 003-2024 and is being held by way of video conference before Justice Robert French, Justice Sir Peter Gross, and Justice Rene Lemiere, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The appellant is represented by Afridi and Angel. Lead counsel is Ms. Zoe O'Sullivan, KC. The respondent is represented by Quinn Emmanuel Urquhart and Sullivan, UK. Lead counsel is Mr. Tom Montague Smith, KC. Thank you.
Thank you. So, Ms. O'Sullivan, you appear for the appellant. And,
I do.
And Mr. Montague
My learned
Smith
friend needs no introduction.
Indeed he does. Well, neither of you do, really. All right. Before we lead off, can I just make the observation that we have had the opportunity of reading your submissions, and of course we're familiar with the background facts to the case, but this is a case about jurisdiction and power, in the context of a statutory court, so that the focus will necessarily be upon the statutes and the rules, to remind the parties that this is not a common law court, it's a statutory court, even though there may be some lengthy expositions based on common law judgments may not necessarily be of assistance to us, but I'll leave it over to you. So, Ms. Sullivan, would you like to take off?
Yes, thank you very much, Your Honour. Good morning, good afternoon, good evening. I had assumed that you were able to read the cases that I referred to in my skeleton.
Yep.
I am going to go to statutes in some of the cases, but I'm ready to be interrupted if I'm taking you into territory that's unnecessary because of your pre-reading. So what I was going to start with is the substantive issues before moving on to whether this is a proper case for the Court of Appeal to depart from its own previous decision, and whether intervention should be a matter for the legislature rather than the court. And then I'll say something briefly about the Part 7 grounds, sort of paragraph 7 grounds on which Justice Martin gave permission to appeal. And before I start, just one factual error I need to correct. I said in my skeleton that Sandra Holding was decided 2 years ago. It was nearly 1 year. It just feels like 2 years.
Okay.
So, Your Honours, the issues between my learned friend and myself have narrowed as a result of the exchange of skeletons. And what is at stake, as Justice French has just said, is an issue of statutory construction, and a relatively narrow one. And the issue, as you know, is whether, as a matter of construction of the court law and the judicial authority law, the DIFC court has jurisdiction to make a freezing order in support of foreign court proceedings which have not yet resulted in a final judgment. And when I use the word jurisdiction, I mean that the DIFC court is entitled to exercise personal or territorial jurisdiction over the defendant. And I agree with my learned friend that it is important to distinguish between jurisdiction and the powers of the court in a case where it has jurisdiction.
There's a term we use in Australia, which I think has some currency in other places, perhaps, that jurisdiction is authority to decide, however defined by reference to subject matter or territory or whatever, whereas power is something that's done in aid of jurisdiction. Although sometimes, yes, of course, you can get a remedial grant of power which carries with it necessarily a grant of jurisdiction to allow the remedy, and that may have something to say in this case in relation to the rules.
It may well. Yes. So I think what I would suggest here is we're concerned with, as I say, this court's ability to exercise jurisdiction over this defendant. I mean, it's not so much. I mean, there's no doubt that it has power to grant injunctions, for example, where it has jurisdiction. The question is over whom and in what circumstances is that power to grant injunctions to be exercised by the court. And just to say that there are a number of other things that my learned friend and I agree on, which is, as I've just said, we concur that this court can only make a freezing order against a defendant over whom it has personal or territorial jurisdiction, and that the source of that jurisdiction has to be the judicial authority law. And we also agree that in a case like this, where the only available gateway is Article 5A1E of the judicial authority law, then the court has to ask itself whether there is a DIFC law or regulation which is apt to confer jurisdiction on the court.
So that's 5A1E is ambulatory in the sense that it can pick up grants of jurisdiction under laws and regulations. And I think the term regulations is defined in such a way that it picks up the rules of court.
It does. I mean, there's a case on this. It's already flown out of my head, but yes, it's Nest Investments. Yes, Nest Investments, a particular rule of court was held to be apt to confer jurisdiction. But as the Court of Appeal has said in this very case, not every rule will do so. And we agree. I mean, you've got to look at the context. I mean, that makes complete sense. And I should make clear that I'm not relying on Rule 2524 of the Rules of Court here as conferring jurisdiction. I do accept that that's concerned with powers, as I think Justice Black has said. But I say that it supports the existence of the jurisdiction, which I contend arises under the court law. So I mean, it's the bottom of the hierarchy, and I prefer to go to the top, which is the statutes.
Yeah.
So, and now my learned friend and I disagree on the relevance of broad idea. And of course, broad idea isn't asking any questions about the jurisdiction of this court. We say assist this court in construing the DIFC legislation because of its unanswerable exposition of the enforcement principle as the basis of the freezing order. And we should say that this court should recognise that the enforcement principle is part of DIFC law, as indeed the Court of Appeal appeared to do in Sandra Holding. So I would like to set out my argument as a series of propositions. 1. Firstly, the DIFC law, which we say is apt to confer jurisdiction in this case, is found in Article 24.1 of the Court Law and Article 7.6 of the Judicial Authority Law, which is common ground, both confer on the court jurisdiction to recognise and enforce foreign judgments. I may refer generally to Article 24.1, but please understand that in each case I'm also referring to Article 7.6 because they both confer jurisdiction. Now,
that's the source of the jurisdiction.
That's the source of the jurisdiction. Then that's my first proposition. My second proposition is this. In a case where the court has jurisdiction under those articles, its power to make a freezing order arises under Articles 22.2 and 32b of the court law, and those powers are very wide. The third proposition is this. I do not contend, and have never contended, that the injunction provisions, the Articles 22 and 22.2 and 32b, of themselves confer jurisdiction. I'm not advocating for a free-standing jurisdiction arising simply because a party has applied for an injunction. The essential point of dispute, this is my fourth point, between my learned friend and myself, is whether the jurisdiction conferred by Article 24.1 is limited to the final enforcement of existing judgments, or whether it permits the making of applications for interim relief in support of the future enforcement of an anticipated judgment. My learned friend's reading of Article 24.1 is very narrow and very literal. He says that it's concerned with the enforcement of judgments, and that an application for a freezing order is not an application to enforce a judgment. And on his interpretation, there simply is no jurisdiction to grant interim relief before the enforcement process has begun. I say that his interpretation ignores the enforcement principle as explained in broad idea, and which is that the purpose of a freezing order is to protect the claimant's right to the future enforcement of a judgment, which will nearly always be a prospective judgment. Once that's understood, there's no basis for reading the words of Article 24.1 as restricting the court's enforcement jurisdiction to the post-judgment situation. And I therefore submit that in the light of the enforcement principle, Article 24.1 of the court law should not be narrowly construed as confining the jurisdiction to make a freezing order in support of foreign proceedings to the case where the foreign judgment has already been rendered.
Should we see
Well, a lot-
P.T. Bayan as saying something analogous?
Sorry, could you say it again, my lord?
Can we see P.T. Bayan, the High Court decision,
Yes,
as
to
saying
come to that.
something analogous? Because that was the
Precisely
case
so.
where there are proceedings pending but no judgment.
Exactly so. I'm going to come to that because that's exactly, although it's very different legislation, I submit that the principle is exactly the same, and that case supports my arguments.
The jurisdiction in that case, the ultimate jurisdiction came from the Foreign Judgments Act. Here,
Correct.
the jurisdiction you say would come from the court's law.
Yes, exactly. And the same narrow construction was advanced by Bayan in that case. They say, well, you've got to construe the jurisdiction can't arise because there's no application to enforce the judgment yet, there being no judgment. And the court, as your lordship knows, rejected that. Let me explain the cases I'm going to look at. I want to look at Mercedes-Benz and the dissenting judgment of Lord Nichols, then at P.T. Bayan, and then at Broad Idea, and then at the three first instance decisions in this court, which have all held that there is jurisdiction, and finally to Sandra Holding.
So what's the proposition to which these, about the statute, which we're concerned with, to which these cases are directed?
Okay, Mercedes-Benz and Leiduc is the source of the current view as to the basis of a freezing order. So it doesn't tell us anything about the statute in this case. It just tells us why the courts grant freezing orders, and that it explains that the right which is being protected is not a cause of action, but a right to future enforcement of a judgment.
I think we understand that.
Indeed, that comes from Broad Idea as well, doesn't it? Do we need to go back to Mercedes?
Right. Well, I mean, exactly. I mean, Broad Idea basically says that Lord Nichols got it right in his dissenting judgment in Mercedes-Benz. But as Justice Lemiere and Justice French will know, the Australians got ahead of the Privy Council in recognising Lord Nichols's approach, and I will be looking at Bayan. But Bayan, I rely upon Bayan principally to show why my learned friend's narrow construction of Article 24.1 is wrong, because the court was asked to do exactly the same thing, in effect, apply the enforcement principle when construing the jurisdiction conferred by the Foreign Judgments Act, and concluded that it would be completely self-defeating for that jurisdiction to be limited to the post-judgment case. But I don't want to get ahead of myself, because I want to look at that judgment in a bit of detail. But of course, I'm very well aware that two of your lordships will be very familiar with that judgment.
And the third has read it.
Thank you.
And coming from here, your proposition is really very simple. The policy is to guard against the dissipation of assets. If limited to supporting existing judgments, the policy benefits are dramatically reduced, and in many cases rendered nugatory. Against that background, you read Article 24 to make sense of it, bearing in mind we are a statutory court, but we're not doing violence to that principle by reading it sensibly. And then the remaining question is, if that's right, was Sandra wrong on this point? And if Sandra was wrong, should we intervene? And that's what the case is about.
Yes, exactly. It is quite a short point. And in fact, your lordship has just anticipated the next paragraph. I was just about to say that you look at it in the context of the public policy. And of course, as you just articulated, the public policy is to show comity to the courts of other nations, particularly when it comes to preventing international fraud. But also there's a particular DIFC policy. I'll come to that in a little bit of detail, which is that one of the objectives of the DIFC is to promote the DIFC as an international dispute resolution centre. And that's not going to happen if the law in Sandra Holdings remains as it is. Because as I say,
this is the kind of argument that approaches the reputational interorum argument that I have heard before and deprecated. I don't think.
Yes, exactly. Well, I'll take that softly. I'm going to allow the cases to speak for themselves. Yeah, I mean, exactly. But I mean, I'm not even going to take your lordships the points. I've set out the points in my skeleton, but there's quite a nice little point. In fact, let's have a look at it now while we're looking. There's a nice little point in the Jersey case, which my learned friend has relied upon called Solvab, I think. Let me just take you there. Yes, Solvalab. If you go to page 1011 in the bundle, that's the case. And the paragraph I want to rely upon starts at 29, which is 1018. No, I mean, I don't want to read out paragraphs 29 to 31, but there is the inter rem argument put more elegantly than I could.
Yep.
Yep.
So we say, and this is relevant to my arguments about departing from Sandra Holding, we say that in Sandra Holding, the Court of Appeal failed to give any proper consideration to these public policy factors, and that they failed to give any proper regard to the enforcement principle. And if they'd followed the reasoning in broad idea, they would have held that there's no rational basis to make a distinction between existing and prospective judgments or between domestic and foreign judgments. What matters, I mean, I don't need to labour the point, but what matters is the applicant must establish jurisdiction by showing a good arguable case that the judgment will be entitled to recognition in the DIFC, and that there's a real risk of dissipation of assets which jeopardizes the future enforcement of that judgment. And that is sufficient to establish jurisdiction. And if those matters are established, in my submission, there's nothing exorbitant in the DIFC court having jurisdiction to grant interim relief to prevent the frustration of the future judgment. But of course, in any case, the court will need to consider whether it's a proper case for the exercise of discretion applying established principles. And the court's exercise of its discretion in Sandra Holding cannot be faulted on the facts. I mean, that was clearly an application with no merit. Now, I want to look, without trying your lordship's patience too much, at the statutory provisions. So if we could look first at the JAL, which I'm sure your lordships are extremely familiar with, we find that in the bundle at page 124. This is Article 5A. And then we have that peculiar reference to exclusive jurisdiction under 5A1. It's an odd concept when it comes to enforcement of judgments, where you wouldn't expect a particular court to have exclusive jurisdiction. And then if you go to page 127, you will find Article 7.6. If you, so that's simply Article 7.6. So if we now look at the court law and go to page 103.
Can I just raise a question while you're on 7.6?
Of course.
So far, there's been, and you'll come to it under Article 24. I just want to focus on orders. The word orders, and just underline it as we pass through it in 7.6, but then pick it up a little bit more strongly under Article 24.
Yes, of course.
Then perhaps
if we could, sorry?
Where are you taking us now?
I'm taking you now to Article 19 of the court law, just to set it in context. So that's at page 103. Because this is part 5, headed jurisdiction of the DIFC court, chapter 1, jurisdiction of the court of first instance. And there we see that Article 19 reproduces the heads of jurisdiction of Article 5.1e of the JAL, save that there's the word original jurisdiction is used in place of exclusive jurisdiction. And I don't know, I can't help your lordships as to why the different word is used.
Maybe it's just distinguishing it from appellate jurisdiction. That's how it's usually used, isn't it?
Yes, but what I don't understand is why it's the JOAO refers to exclusive jurisdiction, whereas this one refers to original jurisdiction.
Is it referring to exclusive to the DIFC rather than the courts of Dubai?
Well, certainly that's the interpretation that Justice Cook has suggested. But again, the idea of exclusive jurisdictions, I just said, is very peculiar when it comes to enforcement of judgments. I mean, it makes sense in terms of substantive jurisdiction. Anyway, so part 24, Article 24 is on the next page at 104. So that refers to 7.4 of the JOAO. In fact, that's just because this provision hasn't been amended. The Court of Appeal indicated in the DNB and Gulf Ayada case that, in fact, that should be read as a reference to Article 7.4 to 7.6 of the JOAO as amended in 2011. I mean, for your reference, that's page 245 of the bundle, paragraph 96 of that judgment. We don't need to look at that. That's Article 24. And as I say, my learned friend says simply, well, you know, its jurisdiction is to ratify a judgment, and that means what it says. No more, no less. And I say not so. So looking up on that page, that the injunction provision is 22.2.
Just before you go there, sorry.
Yes.
Just while we're on 24, if my
yes.
Lords will forgive me. 24 says ratify, which somebody said means enforce, but whatever it means. Judgment, which you say includes prospective judgment.
Yes.
That's how we should read it. That's your point about reading it widely. But the next word is order.
Yes.
And 24.1e deals with orders. Might it be said that a freezing order in Hong Kong is indeed an order squarely within 24?
It might well.
Well, it hasn't.
But as it hasn't.
Yes.
We haven't in this route. We didn't go down that route in this case. We didn't ask Justice Martin to enforce the order of the Hong Kong court, but instead to make the court's own order.
Okay, but if the Hong Kong court order comes within order, that is not irrelevant to your construction of Article 24.
I would agree. I would agree.
Well, it's up to you, not me, to make the point.
Well, the point is this then, is that if the
anyway, I'm
court,
throwing it out there for your consideration.
No, it's fine. I mean, if the DIFC court has jurisdiction to enforce a freezing order by a foreign court, it makes little sense to construe its jurisdiction to make supportive orders as limited.
Right.
So that, I mean, it assists you as to the purpose of the statute.
Yeah.
Now, I was just inviting your honours to note that the injunction, the first of the injunction provisions we rely upon, at Article 22.2, and then if you scroll down to page 109, you will find Article 32. B and arguably also C. This is in Part 7, so this relates to practice and procedure, and Article 32 itself is headed powers. So we don't say this is a jurisdiction conferring provision, and Justice Black came to the same conclusion, and we say that's right. Having shown, I mean, that's the statutory framework. I would like to look briefly at Mercedes-Benz, bearing in mind that your honours will have read it. Then I'll move on to PT Buy and Resources and finally to the first instance cases. So and of course, as your honours know, I mean, the analysis in the dissenting judgment of Lord Nichols has received support from the High Court of Australia and now from the Privy Council in broad idea. The judgment itself begins at page 633. We don't need to go there, but just to remind your honours that the ratio of the decision is that the Hong Kong Rules of Court didn't authorise service out of the jurisdiction of an application for just a freezing order and not a final injunction. But the dissenting judgment one finds beginning at 654. This is Lord Nichols's judgment. Now, I wanted to ask you to look at quite a lot of this judgment. I don't want to try your patience by reading it out or even asking you to read it now, but I do rely upon, in particular, this is the page of the judgment, page 305 of the report from F onwards and to the top of 307B. I'll leave it to your honours to look at that in more detail, but there's just a couple of points I want to flag up as we go through, where he says at G, at the bottom of G, he asks, has the Hong Kong court jurisdiction to grant a Moreover injunction, these called freezing orders, to prevent him from doing so, to remove him assets from Hong Kong? No problem about service because the defendant is a resident in Hong Kong. Justice and convenience suggests that the answer is yes, the defendant is in Hong Kong, and the judgment will be sought to be enforced in Hong Kong through the courts of Hong Kong against assets that are in Hong Kong. So long as the foreign judgment, when obtained, will be recognised and enforceable in Hong Kong, the Hong Kong court should be as able to exercise its wide powers to grant an injunction in such a case as in a case where the judgment is being sought from the Hong Kong court itself. The need for such injunction is particularly compelling when the foreign court has no power to grant interim relief in respect of assets outside its territorial jurisdiction. And then I would also like to emphasise on page 306, the section beginning at C, really to the end of the page, where he explains that the Moreover injunction, the freezing order, is a very different sort of injunction from other types of interim relief because it's not concerned with the cause of action, and it doesn't give the creditor any legal or equitable interest in the assets of the defendant. And then he says at E, this is the famous passage which is repeatedly quoted, Moreover relief is not granted in aid of the cause of action. It's not relief pertinent to a money claim as relief, not so much relief pertinent to a money claim as relief pertinent to prospective money judgment. And there it is. I mean, I don't need to read it out because your lordships are well familiar with that. And then it says at H, once it's borne in mind that a Moreover injunction is a protective measure in respect of a prospective enforcement process, it can be seen that there is a strong case for Moreover relief from the Hong Kong court being as much available in respect of anticipated foreign judgment, which would be recognised and enforceable in Hong Kong, as it is in respect of an anticipated judgment of the Hong Kong court itself. And he goes on.
So we're talking there about something which is purely a power in aid of jurisdiction, or does it carry with it a kind of penumbral or inherent or incidental jurisdiction? In other words, creating an authority to decide, in the terminology I used before, which is, if you like, parasitic on the prospective jurisdiction.
Well, I haven't necessarily embraced the subtleties of the Australian definition, but I would say no. I'd say here that in the Hong Kong court, as in the English court, jurisdiction depends on over the defendant. Jurisdiction in the territorial sense depends on the ability to serve the defendant with process outside the jurisdiction on the court rules. And so in this case, because the court rules didn't permit service out on the defendant, there was no possibility of exercising the power.
Yeah.
So I mean, Lord Nichols thought that was wrong on the interpretation of the rules, but that's my answer to your honour's question.
Yeah.
I did also want to have a brief look at page 310, that's 659 in the PDF. Because this explains something that seems to puzzle the Court of Appeal in Sandra Holding. And he says, given that Moreva relief is of an interim character, it may seem strange that there could be proceedings claiming this relief and nothing else. What is clear is that in the case of an anticipated foreign judgment, where the judgment is being sought in other proceedings, nothing further could be claimed in the Moreva proceedings. And it goes on, he says, in the nature of things, until the judgment is forthcoming, the plaintiff cannot seek to enforce it. Until then, he has only a prospective right of enforcement to which the Moreva relief is ancillary. Now, so there's nothing procedurally, this matter gets before the court by means of a Part 8 application. I mean, that seemed to puzzle the Court of Appeal. They said, well, there's no valid proceeding before the court, and therefore we can't exercise our jurisdiction, or discretion. But that's not right. I mean, we have a procedural rule, Rule 2524, which says that if you're going to make an application of this sort, you have to issue a Part 8 application. And the fact that it's a freestanding application for a freezing order is not an obstacle. It's actively contemplated by the rules. I mean, of course, you can't be applying to enforce the judgment until there is a judgment, but it's a non sequitur, I say, to say that there can be no possibility of an interim application in anticipation of the judgment. And just to make that, to wrap up that point on 660, 311F, Lord Nichols says, likewise, with Moreva relief in aid of a prospective foreign judgment, as already noted, Moreva relief differs from normal interim relief in that it protects a right of enforcement which does not yet exist. However, on the point now under consideration, this difference is immaterial. It is the interim nature of the relief which is under consideration. And on this, the prospective nature of the right protected by a Moreva injunction is irrelevant. So that is Lord Nichols. And I would like now to turn to the PT Bayern Resources judgment, which begins at page 942. And obviously, this is Justice Lemiere's decision at first instance, in which Justice French upheld in the High Court. And of course, the facts were briefly that the claimant, BCBC Singapore, had brought proceedings in the High Court of Singapore against Bayan. Those were still pending, but it had come to the Supreme Court of Western Australia to get freezing orders in respect of shares in an Australian company. And Bayan said the court's power under the Supreme Court rules to make a freezing order was impliedly excluded where the judgment has not yet been delivered. And that argument was rejected at all levels of the court system. So I want to just look at some key paragraphs of the judgment. If Your Honours needed reminding, on page 21948, there is a succinct summary of the conclusion at paragraph 2. I'd like to move from there to paragraph 20 on page 952, because that's I mean, obviously one needs to read the whole case, but this is explaining, of course, the regime for the registration and enforcement of judgments of foreign orders, which we say in our case is Article 24(1) of the Court Law, and then. And paragraph 23, the court observes, what matters is that the money judgment, when given, would be a judgment to which part 2 would apply. Then if one goes on to page 954 and to paragraph 28, where the court makes the obvious point, obviously no application can be made under section 6.1 until such a time as a foreign judgment to which part 2 applies comes into existence. Bayan builds on that inherent temporal limitation to argue that the regime established by Part 2 impliedly excludes any power of the Supreme Court of a state to make a freezing order in anticipation of a foreign judgment coming into existence. So that facile argument was used by Bayan, like my learned friend does in this case, to say, just because there hasn't been an application to enforce, there can't be a power to make a freezing order in anticipation of judgment. And that argument was rejected by the High Court at paragraph 30 on the next page, where they say the regime would be self-defeating, where it be to be read as impliedly excluding such jurisdiction and power as the Supreme Court of a state otherwise has to safeguard the efficacy of those enforcement processes. And then the court went on to consider the scope of the inherent power to make an order to prevent the frustration of the process of the court. And one sees that at paragraph 42 on page 958. And they say that the power is well established. And at 44, Bayan argues that the inherent jurisdiction of the Supreme Court to make a freezing order is always limited to circumstances in which a substantive proceeding in that court has commenced or is imminent. Now, over the page, the key passage of my submission is at paragraph 46. There's a critical point which Bayan's argument misses. Even where a court makes a freezing order, in circumstances where a substantive proceeding in that court has commenced or is imminent, the process which the order is designed to protect is a prospective enforcement process. And there they rely upon the explanation given by Lord Nichols. They quote from his judgment. They refer to the earlier judgment in Cardile and LED Builders, which I'll look at very briefly later on. And then over the page on 49, explaining again, against the background of a freezing order made in advance of judgment being characteristically protective of what at the time of making the order could only be a prospective enforcement, Lord Nichols went on in Mercedes-Benz to point out there was nothing exorbitant about a Hong Kong court making a freezing order in aid of a prospective judgment of a foreign court, given the prerequisite that the anticipated judgment must be one which will be recognised and enforceable in Hong Kong. And then they describe his observations about the alternative result being regrettable as fair. He says the law will be left sadly lagging behind the needs of the international community. And so the summary comes at paragraph 50 on the next page, 961. The power is within the inherent power of the Supreme Court because the order protects the process of registration and enforcement under the Foreign Judgments Act. And we say this reasoning, although this is based on very different Australian legislation, and of course the courts of Australia, the Supreme Courts of the Australian states are courts of inherent jurisdiction, which the DIFC court is not, we say that nonetheless the principle is the same.
When we use the term inherent jurisdiction in Australia, we're really referring to implied power. And when we talk of it in the context of a statutory court in Australia, such as the federal court, we talk about implied incidental power, which would probably be applicable in the problem with using the term inherent jurisdiction is it kind of mixes up two different concepts.
It is. I agree. I agree. I venture with difficulty into that territory. I mean, I think it's quite clear that the DIFC court doesn't have inherent jurisdiction.
Well, it may have implied incidental power. It's a statutory court.
Yeah, no. It has incidental powers. It certainly has implied and express incidental powers, but the source of the jurisdiction is statutory.
Yeah.
Yes. But the ability to read, for instance, Article 24 in a particular way may well be incidental to the express terms, even if it's not inherent.
Yes, it has to be, and that process happens the whole time. For example, why does the DIFC court have power to grant a freezing order in support of an existing foreign judgment? Well, it doesn't say that in terms in the statute, but you read it in. It seems blindingly obvious that if it can enforce the foreign judgment that exists, it must also have powers to grant a freezing order while the enforcement is going on. But as I say, I mean, the statute has to be construed in context, and you can look. I mean, just because it's a statutory court doesn't mean that the court was turn a blind eye to the development of the common law in concepts which are evolving in common law courts. I mean, it would just be bizarrely insular if the DIFC court did not have regard to judgments, say, of the Australian High Court or of the Privy Council.
Which was about a statutory court, provisions of a statute.
Yes.
Anyway.
Indeed. Right. So, I say that the Bayan case really shows that the flaw of this very narrow and literal construction of Article 24(1) until saying, well, there's no jurisdiction until there's an actual enforcement process underway. And the fact that the judgment hasn't yet been delivered, or may have been delivered, it hasn't yet been registered, or no application to enforce has been made, it doesn't mean that the court has no jurisdiction to grant interim relief. It would be self-defeating to construe the law as otherwise. And I note that these authorities are referred to in broad idea, but the Court of Appeal in Sandra Holding doesn't appear to have been shown them. Now, I want to look now at broad idea. It's a long judgment, so I just, again, want to look at brief paragraphs of it. The judgment itself begins at page 22 of the authorities bundle.
Can you try and encapsulate, Mr. Solomon, can you try and encapsulate the proposition relevant to our task, which broad idea is good for?
Broad idea simply, authoritatively and definitively explains that Lord Nichols was right when he identified the enforcement principle as the basis for the grant of a freezing order. And that explains why it's irrelevant to ask whether it's an existing or a prospective judgment, a domestic or a foreign judgment, or a judgment against the substantive defendant, or what we call an NCAD, a non-cause of action defendant. The question is simply, are there assets against which the judgment could be enforced? Is the judgment going to be capable of enforcement? And then the normal requirements for a freezing order, as there risk of dissipation and the discretionary factors.
Well, this all goes to how we should, the sort of legal policy underpinnings of yes. From your point of view, the desired construction of our jurisdiction and powers.
Exactly so.
That's really what it's about, isn't it?
Exactly. I mean, it can't tell you what Article 24 of the court law means, but it can tell you how you should interpret it.
Well, in order to achieve a result which avoids, on your submission, stultification of the prospective jurisdiction of the court.
Yes, exactly so.
Yeah.
I mean, again, I don't want to try your honour's patience, but it might be worth looking at a couple of the points. Unless I'm happy to be halted in my tracks if I'm taking you into too much familiar territory.
I only think that the reservation we have is it's a very long, very authoritative judgment, much of which has rather little to do with the key issues in our case.
Yes, indeed. Well, quite. In that case, let me show you just 2 points, which is, first of all, if you go to page 58, paragraph 89, that is the enforcement principle encapsulated in a paragraph.
All right, well, that tells us the purpose.
Yes, and the other thing I would like to is if you go to the previous paragraph on page 57, paragraph 88, he says, this is Lord Legate, the enforcement principle also explains the basis and scope of the jurisdiction to grant a freezing order or injunction against a third party against whom no claim for substantive relief lies, a non-cause of action defendant, or in the horrible slang, NCAD. So the reason I refer to that is my learned friend has referred your lordship to the previous decision of this court in Alkmaar and Strait. That's the yacht case, where the yacht was held by a company, and the judgment was against the husband in English divorce proceedings. And the Court of Appeal said, well, the judgment isn't against the company, and therefore we can't grant a freezing order against it. Go off and get a judgment from the English court, which they duly did. But as I've submitted all the way through this case, with the benefit of the analysis and broad idea, the Court of Appeal in my submission would have come to a different view. Because with the benefit of this analysis, it's not difficult to see that the court would have had jurisdiction to make an order against the company, because on the basis of evidence that the yacht didn't actually belong to the company, it was in effect holding it in behalf of the husband and was therefore an asset available for enforcement. So clearly the law has moved on since Arkham-Dover. Now, I wanted to look also at the first instance decisions in this court, particularly the Justice Martin's pioneering judgment in Latif, which in my respectful submission got the analysis entirely right, which is at page 369. The court, the record doesn't disclose I was actually leading counsel for the applicant in this case, in this case, the applicant was seeking a freezing order over assets in Dubai, onshore Dubai, in support of proceedings pending in the courts of New York. Now, I want to go straight to page 382, because what the judge did here is what I'm asking your honours to do in this case, which is to have a look at the analysis and broad idea in order to reach a view as to the purpose and meaning of Article 24(1) of the court law. As you can see, starting at paragraph 108, he sets out a number of extracts from the judgment, and then his own reasoning really begins at paragraph 121, where he observes that it's highly likely that these statements of principle will be adopted by common law courts around the world, and there's every reason for this court, as an international common law court, to adopt these principles, including the enforcement principle, as the underlying jurisprudential basis for the grant of freezing orders. And I suspect that's not controversial. And then, essentially, what he's saying, I mean, the next three paragraphs are really the heart of his judgment. And he says, he again is articulating at 122 the policy reasons why you shouldn't have a restrictive interpretation of the legislation. 123 says, well, he explains, he sets out 4 reasons why it would be perverse. He says at 123, such a perverse outcome could only follow from clear and unequivocal requirements or constraints in the statutory provisions. But he says, as in broad idea, the relevant statutory provisions conferring this court's jurisdiction compel the conclusion that the jurisdiction is not qualified or constrained in the manner for which the defendants contend. And then he observes at 124 that although the jurisdiction of the court is exclusively statutory, it doesn't follow that the powers invested by statute to grant injunctions are not as analogous to those historically enjoyed by the courts of chancery, and that the broad unqualified terms indicate that that was the intention of the legislature. Now, the key thing, 125, he says there are no qualifications or constraints to be implied from any provision in the legislation. Sorry, it goes over the page. He says that those powers must be exercised within the jurisdiction of the court, but it is common ground beyond doubt that the court has jurisdiction to enforce foreign judgments. Broad idea authoritatively establishes that the grant of freezing orders pursuant to the enforcement principle is an incident of that jurisdiction. Similarly, he says the same thing at 127. There is every reason to conclude that the DIC courts have ample jurisdiction to exercise their unqualified injunctive powers in accordance with the enforcement principle, which underpins the grant of freezing orders, as an incident of the court's jurisdiction to enforce judgments, whether domestic or foreign, and whether the judgment's been granted or prospective. And then he goes on to observe at 128 that obviously in broad idea, it was clear that the court needed to have personal jurisdiction, but where they're not within the jurisdiction, you have issues with the grant of permission to serve out. And then at 129, he makes the observations about the DIFC court as a court of international jurisdiction, not requiring service out. Now, I think this paragraph has been subsequently misinterpreted as saying that you can simply establish jurisdiction by service on a defendant. But as we'll see from Justice Black's decision in Globe Investment, that's not what he was saying, and I wouldn't support such a wide proposition. So that's Latif. I may come back to the parts of this briefly when we look at Sandra Holding to see that they really misunderstood and mischaracterized what Justice Martin was saying here. But I'd like to go on briefly to Jones and Jones, which is a decision of Justice Cook. It's at 393. This is much shorter because he was in effect following the reasoning of Justice Martin, which he agreed with. In this case, this was not a foreign judgment in the sense of an English or Hong Kong judgment, but a judgment of the onshore proceedings in the onshore Dubai courts. And I observe, because I have to pull his leg, my learned friend was counsel for the appellant in that case and arguing the opposite position from that he's arguing today, but that's just the life of counsel.
We won't hold it against him.
No, indeed. Paragraph 13, that's on page 396. I mean, he says it's really paragraph 13. I mean, he says he would have reached his conclusion in any event, but his views are supported by the decision in Latif, which draws heavily on the notion of the enforcement principle. Now, here was the misinterpretation. The claimant submitted that Justice Wayne Martin found an unfettered freestanding jurisdiction to grant injunctions without reference to any of the gateways. Well, obviously he didn't do that. And then there was the alternative submission. We'll come back to that. So he then sets out paragraphs from the judgment in Latif, and at 18 he said, I, like Justice Martin, see no difficulty in adopting this principle, the enforcement principle, without reference to the gateways in Articles 5.1a to d in the light of E and the terms of Article 7 of the JOAO, Article 24 of the Court's law, and the terms of the RDC. This is not an arbitrary exercise of jurisdiction, which in any event depends upon effective service, which is not now here an issue. And he says the jurisdiction to grant interim injunctions is by reason of the wide wording of the provisions where it referred without any limitation of the kind that the defendants would like to impose, and by reason of the enforcement principle, a necessary adjunct to the powers given in relation to the enforcement of judgments now, I think it must mean, we haven't got a full page, but I think it must be judgments of foreign courts and the Dubai courts. I do not see the need myself to describe it as a freestanding power, and it's not arbitrary, since its exercise will be limited by reference to principles referable to the grants of interim injunctions of this kind and interim injunctions generally. And then he sets out the public policy reasons at paragraph 20. He's not usurping the Dubai.
All of this citation of authority is directed to a purposive construction of the court's jurisdiction and powers.
Yes.
And that's really it. And it's the purposive construction is a construction that accords with the purpose specified in what you call the enforcement principle.
Exactly so. I mean, of course, and there's one more to come, which is just
Is it also relevant, Sir Sullivan, is also relevant to whether this court should or could depart from Sandra Holdings in view of cases before it, the evolution of the principles?
It is. I'll be coming to that point, but I say that where you've got 3 first instance decisions by 3 very experienced common law judges, saying that they consider there should be jurisdiction, that the statute should be construed so as to confer the jurisdiction for which I contend, then that is a powerful pointer. That I say that the Sandra Holdings has taken the river out of its course, and you need to return it to its course. It was all flowing in the right direction by virtue of 3 these decisions, and now something went horribly wrong last September. And so, I mean, I don't want to anticipate my submissions, but essentially, Sandra Holdings is the outlier here. Sandra Holding does not represent the settled law. Sandra Holding has diverted the law the wrong way for the last year, and that's why it's appropriate for this court to divert it back. And of course, that doesn't mean you're bound by the reasoning in these decisions, but in my submission, these 3 judgments show the right course. And I just look very briefly at Globe Investments. This judgment didn't come out in time for the hearing in Sandra Holding. The hearing in Sandra Holding was May. This judgment came out in July, but it could have been provided to the Court of Appeal, who didn't give their judgment until September, but it wasn't for some reason. I don't know why. And this is very complicated facts, but essentially, this is a return date because the applicant had a judgment against some of the defendants, not all of them, and was trying to get freezing orders, sustained freezing orders in the DIFC court. And there were various, there was an argument about jurisdiction under one of the other gateways, but that was rejected. And so when we got to page 4, we get to 428, is where you see Justice Black dealing with the argument under Article 5E. And yet again, it was being argued, despite the 2 previous decisions, that the power only arose post-judgment. Now, paragraph 48, yes, that's where you get to the reference to Article 5A1E. Now, oddly, in this case, the applicant appears only to have relied upon the injunction powers and Rule 2524 of the Rules of Court, but not on Article 24.1, which makes rather a hole in their arguments. But at 52, he said, well, the injunction conferring powers, the Articles 22.2 and 32 of the court law, don't confer on the court a jurisdiction that it does not possess under the JOAO. Rather, it's describing the powers of the court in the exercise of that jurisdiction. And he says Article 32 is under the section of practice and procedure, and it's expressly a power conferring provision. Consequently, I don't accept that either Article 22 or 32 of the court law advances Globe's argument. And then he goes on to examine the enforcement principle. And at 65, he rejects the suggestion that mere service establishes jurisdiction. And he also says at 66, I don't derive from Latif support for the proposition that even where a defendant challenges jurisdiction, either that mere valid service is an answer or there's a special rule applicable only to worldwide freezing orders. So, I mean, again, that's not a point that I would seek to argue in this case. And then he says some interesting things about service in the DIFC, paragraph 72 and 73. And of course, Justice Platt is very familiar with, he wrote the rules, and he's obviously practiced in this jurisdiction for many years. And so his explanation of the jurisdiction of DIFC is interesting in paragraph 72 on 435. And he contrasts the common law courts, where service depends on the right, jurisdiction depends on the right to serve out, with the DIFC. But he points out at the beginning of 73, it is, however, necessary that the defendant be an actual potential judgment or award debtor on non-cause of action defendant. We respectfully agree. And then applying that to the facts, he says, well, one of the defendants in this application isn't a judgment debtor and it's not a non-cause of action defendant, so they get a freezing order, but it does grant a freezing order against some of the other defendants who are judgment debtors. And I just simply observe an example of the control mechanism working effectively. So, as I said, you have 3 cogently reasoned jurisdictions, judgments at first instance, all of which reach the conclusion that there is jurisdiction that we contend for. So really, I'd like to look briefly at Sandra Holding. Again, I know that your lordships will have read that, but if we could look at page 9, where the substantive reasoning starts. It actually begins, there's an orphan at the bottom, it says discussion and analysis, and then you have to go to page 10 to get that. And at paragraph 52, the court sets out the issue which it has to decide. Do the DIFC courts have jurisdiction to grant a worldwide freezing order in circumstances where none of the parties fall within the scope of Articles gateways A to D, and the only gateway relied upon is E. And paragraph 53 says there's no express provision which states that they have such jurisdiction. In my submission, that there's no obstacle. Then if you go on to page 50, paragraph 54, curiously, the respondents in this case seem to have rested their argument on RDC Rule 25, 24. As I've said, that's really the bottom of the hierarchy. I mean, I would start with the court law, but for some reason they chose to concentrate their fire on the procedural rule. And then, so understandably, the court has a few things to say about that. For example, as we saw in 58, they say the RDC cannot add to or extend the jurisdictional powers without clear expressive words. And of course, not every rule confers jurisdiction, and you have to look at it on a case-by-case basis. That's obviously all very sensible. And then at 59, it says, well, 25, 24 is not apt to confer jurisdiction because it's purely procedural. Again, I don't dissent from that conclusion. I just say it's consistent with my arguments on jurisdiction, not that it's a source of jurisdiction. Now, but of course, we get to the real meat of it at 63 on the next page, where the court notes that they also rely upon Articles 22, 24, and 32 of the court law, which they then set out. And then at 64, they make the observation that these articles are intended to provide general powers in the creation of DIC courts. Individual provisions of that law are not intended, unless clearly worded, to confer any special powers or jurisdictions on the court. I mean, that doesn't get us very far because, as we know, the wording of Article 24.1 does expressly confer jurisdiction. And the question is, what is the scope of that jurisdiction? The crux of the judgment, really, the key paragraph in this judgment is paragraph 65. This is really where the substance of the reasoning, such as it is found. And Article 24.1 is dismissed in a single paragraph. And they say simply, Article 24 of the court law provides jurisdiction to ratify a judgment, order, or award. That is not a source of jurisdiction where there is no judgment or award to ratify. None of the articles in the legislation provide the court with the power to issue injunctions in aid of anticipatory foreign judgments. Why not? The reasoning given.
What does that term ratify mean, by the way?
It's
is it the equivalent of recognise or?
Yes, it is. It's yes, that we've been over that territory in DNB Bank and Gulf Layada. Basically, they say that's what it means. It means enforce.
Yeah.
There's no difficulty about that. Everyone reads that as meaning recognise and enforce.
Sorry, recognise as well as enforce.
Well, enforcement must imply recognition. I mean, I think we can look at, if you want to, we could look at what they say in Gulf Layada.
No, I wasn't suggesting that.
I mean, I think what they say there is enforcement. It means you can enforce. That is the provision that gives jurisdiction to enforce judgments. But I mean, that it must be implicit in that recognition. I mean, you can't, as I say, you can't enforce without recognising. Although you might recognise without enforcing. But returning to paragraph 65, which is really all you get from the Court of Appeal in Sandra Holding, is this assertion that, well, Article 24 doesn't confer jurisdiction in relation to anticipated judgments. Why not? Well, the only justification given is the final sentence, which is frankly very difficult to understand. I've spent quite a lot of time trying to understand what it means, and I don't even now, I'm not sure. But it says, if the respondents were correct to say Article 24 conferred DIC court jurisdiction over matters which are yet to be decided, on the basis that there may be a judgment sometime in the future, the effect would be the court would have exclusive jurisdiction over those matters, which is clearly not the correct application of Article 24 or application of the JOAO court law or the RDC. Now, that is puzzling. What do they mean about matters which are yet to be decided? I mean, that can't mean the substantive merits, because the DIC court will never be asked to decide that. That's a matter for the foreign court. And then if they mean, well, we're being asked to anticipate now whether there'll be a future judgment capable of enforcement, well, yes, they are, but it's just an interim application. I mean, any freezing order, you have to form a view as to whether there's going to be a judgment. But that's simply for the purposes of meeting the interim release standard. It's not binding on the trial judge. And then again, the reference to the court having exclusive jurisdiction over those matters, whatever those matters are. I mean, obviously, if they're talking about enforcement, the DIC court isn't going to have exclusive jurisdiction to enforce a judgment of the Hong Kong court or any other court. I mean, that could be enforced anywhere where the courts will enforce it in accordance with their own rules. So it's all very puzzling. It doesn't make any sense in my submission. And then we get to Article, so that's Article 24.1, that's just dismissed. Article 32 is also dismissed on the basis that there has to be a valid proceeding before the court. Again, if there's jurisdiction, there's no difficulty with that. You issue your Part 8 claim, and then there's a valid proceeding before the court. And then they refer, paragraph 67, to the DNB Bank case, deciding that those articles of the JOAO are source of jurisdiction for the enforcement of foreign judgments. But they say this doesn't provide jurisdiction for an interim relief order. Why not? So there's no evidence in the Court of Appeal's reasoning to suggest that they have the jurisdiction where it's a prospective judgment. Why would it? They weren't being asked to decide that question. It didn't arise. Why on earth would they have expressed a view on a matter which didn't arise? So that's, again, puzzling. And then they go on to 68. Clearly, they understand that reliance has been placed on the enforcement principle, and there's the reference there to Latif. But 69 just mischaracterizes Justice Martin's decision in Latif. It says the decision did not address the absence of a relevant law, which would, in combination with Article 5A1E, ground jurisdiction in those circumstances. I mean, that's just not true. Justice Martin relied on Article 24.1 of the court law. I mean, that seems to pass the court by. They say here Article 22.2 and 32b of the court law. But they seem to have omitted to notice that he actually relied upon Article 24.1. And just to show you that, if we could go briefly to page 381 of the bundle. And that's, if you look at paragraphs 105 to 106, now 105, he does refer to the injunctive provisions, but then at 106, he says, if these provisions apply without qualification so as to support the prospective exercise of the court's undoubted jurisdiction with respect to the enforcement of foreign judgments, being the jurisdiction created by the combined operation of Articles 5A and 1E and 7.6 of the JOAO and Article 24 of the court law, then Article 5A1E is itself a statutory source of jurisdiction for the exercise of those powers, read with the provisions of the court law and the RDC to which I have referred. Now, the Court of Appeal has just mischaracterized the judgment of Justice Martin. And if we go back to Sandra Holding at page 14, and they say at 70, it's important to recognize the underlying principle of a freezing order, and when granted its relevance and support to the prospective enforcement of a judgment, that's the enforcement principle. The necessary question with which the court has always been concerned is whether it has jurisdiction under its statute to grant such relief. Fine, that's a statement of the obvious. The question is not whether it should have jurisdiction merely in order to avoid a less corrupt and perverse outcome. I mean, that suggests that that Justice Martin was effectively sitting under a palm tree and deciding there ought to be jurisdiction because he thought it'd be perverse otherwise. Of course, he was doing nothing of the kind. What he was saying is, given that you've got these powers, it would be perverse to construe them as limited in the way suggested in the absence of clear wording. He said there was no such clear wording.
Sorry, Ms. So is the right question, does the court have jurisdiction under its statute to grant such relief, or does it have power under the statute to grant such relief in aid of its jurisdiction, which is the enforcement jurisdiction?
I would say the latter formulation, Your Honour.
Yeah. We're not dealing with a satellite jurisdiction.
No, I'd say the court has jurisdiction to enforce foreign judgments. The court has power to grant freezing orders. And you construe 24.1 in the light of the enforcement principle to show that it's not intended to limit the power to grant an injunction to the post-judgment case.
Yeah.
So
now we've lost the photograph of the picture of Sir Peter. I just want to make sure we haven't lost Sir Peter.
No, I'm here.
Oh, good to hear. Okay. Thank you.
I'm sorry, I didn't. Thank you. I didn't realize. There we are.
Yes.
Thank
So,
you
I
very
mean,
much. No, I've been here.
Could-
I've been here and listening quietly.
but can I show? I mean, the way I put it is the way it's put at paragraph 106 of Latif. Which is at 106. That's page 381. So he's articulating the question of if these provisions apply without qualification. So he's asking, I mean, he's asking here, is there any reason to suppose that the power to grant injunctions is limited, or do they apply to support the prospective exercise of a court's undoubted jurisdiction with respect to the enforcement of foreign judgments? And then he asks whether the provisions of the court law and the RDC must be read subject to some qualification. And he says, no, it will be perverse to, well, he doesn't say, he says that later. He says, and that's when we get to broad idea. And that's why he says, in the light of broad idea, you don't read the injunctive powers as cut down. So he is construing here the scope of the powers under Articles 22 and 32. But it's quite clear, saying that it is incidental to, the power is incidental to the jurisdiction to enforce foreign judgments. And I return to Sandra Holding at page 14. There's just a few more observations I'd like to make about that judgment. At paragraph 71, there's a reference that says the court doesn't have any statutory basis to assume jurisdiction by extending the conduit jurisdiction principle to matters which are not within the scope of the DIFC court. I mean, again, I find that puzzling, because the court isn't being asked here to extend the conduit jurisdiction principle. It's being asked to exercise its own jurisdiction in support of proceedings in Hong Kong, or in this case, I think it was France and Kuwait. And again, paragraph 72, the court thought it was helpful to point out that in the DIFC, there's no express statutory power, but there is in English law under section 25 of the CJJA. Now, again, I don't want to go over territory that you're familiar with, but the point about the broad idea essentially shows that you don't need an express power, or that section 25 at least didn't need to be enacted. Section 25 was originally brought in to give effect to the UK's obligations under the Brussels Convention in relation to enforcement of Brussels Convention judgments. It was then extended to all judgments worldwide because of the Siskina was thought to suggest that you couldn't get a freezing order unless you had the substantive cause of action in the English court. And so it was enacted. And now we know from broad idea that that was mistaken. But of course, people are continuing to rely in England on section 25, but they don't need to. They could have. We now know from broad idea that even without section 25, the enforcement principle gives the in the light of the enforcement principle, there are other sources of jurisdiction. And of course, in England, there was an express service out of the jurisdiction gateway has been created, and so that's why people now rely on that. I mean, you make your application under section 25, you've got an express gateway under Practice Direction 6B, so people continue to rely upon that. But the fact that there's no service gateway in the DIFC is entirely irrelevant. Now, and then just briefly, they say at paragraph 74, the principle that in personam jurisdiction in the DIFC court is not established by way of service was laid out in the Court of Appeal's decision in Ark Moldova. Correct. I don't disagree with that, but it doesn't advance the question at hand. And again, the Ark Moldova decision, I mean, it doesn't seem to have been explained to the Court of Appeal that the broad idea in effect shows that Ark Moldova was wrongly decided. But that hasn't been explained to the court. And then really that's the end of the substantive discussion of jurisdiction in this judgment, except we should probably look very briefly at page 19, paragraph 99, this very odd and ambiguous paragraph, which is one of my other grounds of appeal, but I don't want to spend too much time on that, because it literally says that the court will consider granting an injunction even though it hasn't got in personam jurisdiction. Anyway, but I mean, as I say, the rest of this judgment is then concerned with an analysis of the facts, and the application is dismissed on its facts. And as I say, that analysis can't be faulted. This obviously was a totally unmeritorious application. So
if this court were to take the view on appropriate principles that Sandra Holdings was wrongly decided as to power/jurisdiction,
yes,
it would not have made any difference to the outcome in Sandra Holdings.
Absolutely not. I mean, it wouldn't have made any difference at all in that case. The applicant had brought proceedings in Kuwait and France. I mean, they'd be dismissed in both courts, and moreover, there was an exclusive Cayman jurisdiction clause. So none of those judgments, even if the court's been prepared to grant them, would have been capable of enforcement, because the DIFC would have simply said, does the foreign court have jurisdiction over the defendant in accordance with our conflicts rules? Answer, no. Go away, no freezing order. I mean, it was just the most unmeritorious case, and it's unfortunate. They say hard cases make bad law, and that seems to be the case here. But there's no quibble in the analysis of the application of the principles to the facts is you know, the analysis of the evidence is not, you can't fault it in my submission. But what I do submit is that there's an absence in this judgment of any serious consideration of the issues raised on jurisdiction about the application of the enforcement principle and the public policy issues, such as the need for judicial comity and the role of the DIFC court as an international commercial court. And that's one of the reasons why I say this court should revisit the question afresh, and simply in absence of any comprehensible reasoning to support the conclusion.
Well, now, that's a little harsh. Only a little. What the court there said was there isn't jurisdiction.
Yes.
Therefore, no injunction. What you can say fairly is there was nothing by way of additional observation about the fact that as a matter of policy, it would be desirable if there was jurisdiction. That they don't say.
Yes.
So
my criticism goes. It goes a little further than that, because what they say is there's no jurisdiction because Article 24 only applies where you've got an actual judgment. But that isn't reasoned at all. It's simply stated, except for that one sentence we saw about, we'd be assuming jurisdiction over matters still to be decided, which is A, incomprehensible, and B, wrong. So, I mean, I am being harsh, but I mean, it's
hard to know how it can be both incomprehensible and wrong
without explanation.
It's like what they say about string theory, not even wrong.
I have a note to talk about public policy, but I'm not going to. I've shown you that extract in the Jersey case, and it might be worth looking at. I don't know if you want to see the objectives of the DIFC court. If you go to page 133, this is well, it's number 5 of 2021. Exactly, you know that. So in my submission, it's not likely to promote those objectives. Now, coming to the question of whether you should depart from the previous decision of this court. Now, my learned friend agreed that is open to this court, but it is rare for there to be a case in which it's appropriate to do so. And of course, you know, that depends on the consideration of the particular case. And so I can cite lots of cases where it wasn't or was done, but that's not going to assist much. What I would observe is that the Privy Council, in broad ideas, said, well, in order to depart from our own previous decision, there would need to be a compelling reason. That's why they That's how they put it. And of course, they weren't prepared to depart from authority on the construction of the service out rules, but they were, at least the majority was, prepared to overrule the Siskina. So that in itself is quite an interesting.
There's a set of principles I should draw to your attention, and also to Mr. Montague-Smith's, in a High Court decision, which you might like to make a note of, John and the Federal Commissioner of Taxation, which is 1989, 166, Commonwealth Law Reports 417, and looking at 438-439. And there were 4 relevant considerations set out in that. Now, we're not talking here about overruling a constitutional case, because the threshold is a bit lower there, because in constitutional cases, you can't get legislative amendment. So the court says, well, we'll adhere more to what we think is right about the Constitution than about our previous decisions. So we're looking at a statutory situation here. And so the 4 considerations are: 1, whether the earlier decision rested upon a principle carefully worked out in a significant succession of cases. Then 2, which is not applicable here, whether there was a difference between the reasons of the justices constituting the majority in the earlier case. Here they were unanimous. 3, whether the earlier decisions had achieved a useful result or caused considerable inconvenience, where, well, I can see your point there, and no doubt Mr. Montague-Smith will have a different point. And 4, whether the earlier decision had been independently acted upon in a way which militated against reconsideration. And that goes, I suppose, to questions of recency and so forth. And of course, the other consideration, we've got the questions of certainty and not changing decisions just because it's changing the composition of the court and all those sorts of things, which militate against predictability of outcomes.
Thank you. That's very helpful. And I would suggest that, as you say, the second of those doesn't apply, but certainly applying the first, third and fourth, all of those have relevance, and I'll try to address those on the fly, as it were. Can I also, if we look at the practice direction of the practice statement of the House of Lords from 1966, should be in, there was an updated joint authorities bundle, which I hope you've got, at page 1170. But obviously this is...
I don't think I've seen that. You better just read it out.
Yes, sorry. Essentially, it's a very short statement when the House of Lords decide that they will depart from their own previous judgments. And they say this: their lordships regard the use of precedent as an indispensable foundation upon which to decide what is the law and its application to individual cases. It provides at least some degree of certainty upon which individuals can rely in the conduct of their affairs, as well as a basis for the orderly development of legal rules. Their lordships nevertheless recognise that too rigid adherence to precedent may lead to injustice in a particular case, and also unduly restrict the proper development of the law. They propose, therefore, to modify their present practice, and while treating former decisions of this House as normally binding, to depart from a previous decision when it appears right to do so. In this connection, they will bear in mind the danger of disturbing retrospectively the basis on which contracts, settlements of property and fiscal arrangements have been entered into, and also the especial need for certainty as to the criminal law. So those are other matters that may be of assistance in deciding whether this is an appropriate case. So in my submission, Your Honours, if there was ever a case in which it was appropriate to just depart from a previous decision of the Court of Appeal, it is this one. This is not a case where there are doubts as to the correctness of the decision. The decision is plainly wrong, plainly inconsistent with the DIFC public policy, and it turns the DIFC court into an outlier among common law courts, which can be expected to follow a broad idea and apply the enforcement principle, irrespective of whether the judgment has been delivered or not. As the law stands, the DIFC court is not assisting foreign courts in the prevention of international fraud. The Dubai courts, the federal onshore courts, cannot provide the assistance which a common law court can. Their remedies are much more limited than those of the common law, and the limitations of the remedies of the Dubai court were considered by Justice Cook in Jones and Jones. I would take you there, but it's at page 397. Paragraph 22 in Jones and Jones. Now, the decision does not represent the settled law in the DIFC. It was reached a year ago after 3 previous first instance decisions had reached the contrary conclusion in line with broad idea. It cannot therefore be said that many parties have conducted their affairs in reliance on it during the past year, such that it would now be unfair to change the law. This decision is concerned with interim relief. Departing from the decision will not have the effect of retrospectively affecting property rights, settlements, or fiscal arrangements. It will have no effect on the criminal law. And in terms of the John and Financial Commission for Taxation principles, Sandra Holding diverts from a settled line of reasoning in the DIOC courts following reasoning in the Privy Council. And has it led to a useful result? Well, I don't have any evidence of that. Anecdotally, I'm asked to advise whether a freezing order can be obtained in support of foreign proceedings at the DIOC court. I have to say no, but I've got no evidence of that except. Really, is there any suggestion that this has been acted upon? No, I mean, this decision has only been enforced for a relatively long time. Relatively short time, and it can't be said that changing the position now would sort of retrospectively alter the way in which a large number of litigants have acted. And so, in my submission, this is one of those rare cases where there is a compelling reason to depart, in the words of the Privy Council and broad idea, or where it is right to do so, in the words of the High Court of Australia. And then the other question, of course, is whether it's better for you to leave it to the legislature to intervene. Of course, this, of course, is a very fact-sensitive matter. I've put in the bundle a couple of lectures by justices of the Supreme Court in England. For example, I won't take you there, but Lord Hodge says, judges recognise that there's boundary to judicial lawmaking, but there's no consensus as to where it is. For example, and again, Lady Hale, in her 2016 lecture, refers to a case on accessory liability in criminal law, where she says, well, that's a case where the courts got it mixed up and it's for the courts to set it out. But there's no clear, bright line. But it's
often been said, forgive me interrupting, that there's a consideration of comparative institutional competence. I think Lord Bingham may be the originator of that. If you look at this area of the law, we'll hear from Mr. Montague-Smith, no doubt, but you might have said that the delimitation of jurisdiction in terms of freezing orders is not obviously a matter where the legislature enjoys advantages over the courts.
Yes. Well, I mean, yes, I do say
that. We aren't
that.
dealing with the allocation of resources.
Well, I do say that.
Projects.
I do say that. I mean, it's a sort of thing that's very fiddly to enact into legislation. And who knows whether or when the JAL would be amended to confer the jurisdiction which my learned friend is lacking. And that's the point, that in this area particularly, this is a common law made remedy, and we see it evolving constantly. But broad idea being a very good example of that, and that shows the flexibility that the courts have to adjust and to respond to decisions in other jurisdictions, and that's exactly why I say this particular case in relation to jurisdiction to grant freezing orders is peculiarly the appropriate province of the courts, and not something that's apt for codifying in law. Justice French has something.
You don't need a social consensus, for instance, on this.
You don't. I mean, this is not a matter of public law. This is a matter of remedies. It's a matter of a well-established remedy, and the limits of the jurisdiction to intervene in civil proceedings. I mean, it's simply not a difficult constitutional or public law issue.
There is a proposition, however, that 5A1E picks up jurisdiction conferred by regulations, which include rules. And yes, you could have a rule of court which is ultimately enacted by the President, but on the recommendation of the Chief Justice, a simpler legislative process under which it could specify that the court has the power, and if you want to call it that, the jurisdiction, to issue freezing orders in respect of pending proceedings in a foreign court whose judgments could be ratified in this court. It's not an all or nothing thing with it's either the ruler or the court.
Yes, I mean, yes, I understand that. You could amend 2524 so it says in terms the court shall have jurisdiction and not so simply procedural. But in my respectful submission, that would be a very odd place to put a jurisdictional provision in the procedural rules, and it's simply not necessary. And what we say here is this is a straightforward point of statutory construction where the Court of Appeal has gone wrong and the three previous decisions got it right, and it's very simple and straightforward. Your Honour, simply to issue a judgment correcting the error and setting the law back in its correct course. I mean, much easier and more flexible for the court to do it than to leave it to amendment. Who knows? You know, it's a matter of speculation whether resources will be allocated to this exercise. I mean, the resources of the legislature are unlimited. And for example, in Dubai, there's no equivalent to the Law Commission in England, which identifies areas that need reform and has the benefit of carrying out all the analysis, the history and comparative legislation. So, I mean, the English legislature has huge advantage in terms of the Law Commission's work, but there's nothing like that in Dubai. So I'm asking this court to step into the breach rather than leave it all for some future amendment of the legislation, which in my submission is entirely unnecessary. All we have to do is construe it in the way that the first instance judges have construed it, consistently with the enforcement principle. So, Your Honours, my note says the paragraph 7 grounds, but I'm not going to trouble you with those unless you want me to.
Thank you very much.
Thank you. Those are my submissions, unless you had further questions for me, Your Honours.
Questions? Mr. Montague-Smith.
My lords, so as the court's heard, there are essentially two parts to this, and you've not been troubled with the paragraph 7 grounds, and I'll either leave those to one side depending on your indication or deal with them extremely briefly, but the focus today is on what's been referred to as the paragraph 8 grounds, and that is, was Sandra Holding wrong or per incuriam? And those are the grounds on which permission was granted by Sir Peter Gross, as we recall, albeit I remind your honours that Sir Peter's decision was that had it not been for the merits of its wrong grounds, then the per incuriam ground would not by itself have been granted permission. So what I say about this is, firstly, as you might appreciate, we say Sandra Holding was correctly decided. And indeed, quite a lot of what was decided in Sandra Holding isn't challenged. So points about freestanding jurisdiction for injunctions, points about the rules giving rise to jurisdiction of the territorial sort, that is not challenged. And so in this case, jurisdiction is being argued on a much more narrow ground, much more narrow basis than it was in that case. But my first point then is going to be, and I'll break it down, Sandra Holding's right. My second point is, even if you disagree with that, this court should not overturn this primarily on the basis of the principles of stare decisis. So on one view, one might deal with those issues the other way around, but I do accept that there are occasions when this court, as the highest court in the DIFC, can overturn its previous decisions. So it's necessary to understand what circumstances justify that, and then look at the decision to determine whether or not it fits within that sort of category. I'm going to deal with it on the other way round. Is it right? And then even if it's wrong, should you interfere with it and adopt, if I may say, actually the approach of the Master of the Rolls in the Convoy and Broad Idea case itself, because you'll see that that's the way that he approached the territorial jurisdiction issue. But both of these issues are of some significance in this court, as the court can no doubt appreciate. But I would suggest in some ways the stare decisis issue is more important. That there is room for legislative reform of these principles that we have today, but stare decisis will be an issue that this court will build for itself, if I can put it like that. And so that is not something the legislature is ever going to change. And we know that there is legislation before the legislator now looking at these particular provisions, looking at the court's territorial jurisdiction. And it may well be that this issue changes quite radically, and this decision, any decision on territorial jurisdiction that you make, any interpretation of the current status of the legislation, doesn't actually have the long-term effect that some characterize it as having. But stare decisis will. Stare decisis absolutely will.
Is this a case which we should approach the analysis? I think I've already laid this out to Ms. O'Sullivan, that the real question is whether the court had a power to make an order in respect of its prospective foreign judgment enforcement or ratification jurisdiction.
No, I disagree with that characterization. I'll come on to explain why. And I'll show you how that was approached in Susquehanna, Mercedes-Benz, and then in Convoy. But the way that it was put in the Mercedes-Benz case was that effectively the majority accepted in that case that there was real force in Lord Dickel's dissent. But they were saying, even if you get to that point, you can't just have a power in the ether. You can't just exist in the air, is how they put it. You need to have a vehicle for that, which confers territorial jurisdiction.
Well, you need to have a jurisdiction which it aids.
Yes, correct.
Yeah, okay.
Correct. But an existing one.
Whether you call it territorial, sorry, whether you call it, I'm a bit concerned about the territorial personal stuff, because the terms in which jurisdiction is conferred on the DIFC courts are not expressed in that language, are they? If you look at 5A.
No, they use the word jurisdiction, but yes. That clearly has to be a distinction between territorial jurisdiction and power, which is how I define the distinction. And that is the approach that you will see flowing through all of the authorities that are relied on. Now, in England, it arises in a particular and distinct way, because the way it works in England is the starting point in the old cases was that the court only had jurisdiction over individuals who were in England. And then it started to develop its what in some cases has been called exorbitant jurisdiction, but without using the pejorative nature of that term. But those circumstances in which the court could exercise jurisdiction over somebody who was not within the confines of the territory are defined by reference to whether they can be served out, whether service of proceedings can be made onto them. And that is set out in a series of rules, which I will take you to just to show you that actually those rules are very similar, or the relevant rule is very similar to the particular provision that is being urged on you as conferring jurisdiction in this case. And that rule has been looked at in a number of different jurisdictions. And on every case it's been looked at, that court has said it does not confer jurisdiction over this sort of claim for an injunction in support of a foreign judgment that hasn't yet arrived. So there are examples of cases, and Mercedes-Benz is a good example of it, where the court has looked at precisely this legislation. There's one in Jersey as well, the courts and so it's not a case of the court saying I have the power, so how is my exercise of it limited? The question has to be: is this claim, which is a claim for an interim injunction, a claim that this court has the authority to decide? And that is determined by reference to the four corners of Article 5, Article 7.6 is the source of it. And there's no dispute about that amongst either the parties or the authorities. The parties and the authorities are clear. Jurisdiction has to come from the judicial authority law. So, and the way it works in the judicial authority law is it sets out a series of descriptions of claims. And it says the court has power, has the authority to decide, has the jurisdiction to exercise its powers in relation to these sorts of claims. So it's a description of types of claims. Now, one of those looks like an in personam jurisdiction because it says claims by or against DIFC establishments. It's still a question of whether the claim fits the description in Article 5 of the judicial authority law, but those are the confines. So if one puts the question as, well, we've got the power to grant an injunction, should we limit that in this case, which is how my learned friend approaches the question, what you're doing is you're assuming the conclusion, and you're actually assuming the accuracy of an argument she has disclaimed, which is that the injunctive powers of this court confer one way or another jurisdiction. That is not an argument that's being advanced. So what we have to do is we have to look at the gateways that are identified and ask ourselves the question, does the claim that you have before you fit within the description of the particular provision that's been relied on? And Article 5A1E and Article 24 of the court law is the first example, and Article 7.6. Now, my learned friend didn't identify any particular differences in the language between those two provisions. I'll look at them both, but ultimately, so I'll call those the sort of enforcement gateways, if I may. Now, that may be said that that's tendentious, and if you disagree with that, then we can think of something else. But that's a convenient characterization. Now, we had thought that there was an argument that the injunction powers of the court that you find in Articles 22 and 32 could themselves be, quotes, apt to confer jurisdiction in terms of the nest investment. Now, we've covered that off in our written submissions, but it has been made abundantly clear that that is not the case being advanced today. And the way it is being put, and I take this from my learned friend's supplemental skeleton, paragraph 8.1, she says that Articles 22 and 32 of the court law do not themselves confer jurisdiction on the court. They confer very wide powers to grant a freezing order in a case where the court has jurisdiction. And I don't take any issue with that summary, and we don't argue against the enforcement principle properly understood as elucidated in broad idea. Where the court has territorial jurisdiction, we don't argue against the proposition that it can make injunctions in support of foreign proceedings in anticipation of a future judgment. That's what I would describe as the power issue. And so there's no issue arising in relation to the power issue, but there is an issue arising in relation to the territorial jurisdiction issue. Now, so that actually so far is common ground, what I've just described. But there is a difference.
Forgive me, there are two questions, and to me, relatively straightforward, even if the answer may not be. The first is, does the court have jurisdiction, which requires an examination of 5A, 1E, the numbering sometimes defeats me, together with Article 24 and perhaps Article 7.6. If on an appropriate construction, Ms. O'Sullivan can bring the matter within those provisions, then the court has jurisdiction to grant an injunction. The second question, separate question, is whether, if there is jurisdiction, the court should exercise its discretion or power to grant an injunction. The second question doesn't arise until the first question has been answered yes. So the first question is simply a matter of statutory construction of those provisions.
Correct.
And then in this case, assuming you've come second on questions 1 and 2, there's a third question, which is whether we should do anything about it or leave it to the legislature. That's, to me, those are the fairly straightforward questions which arise.
Yes, the second doesn't arise because there's no issue.
Because you accept that if there's jurisdiction, an injunction should be granted.
Well, we don't accept it, but we accept that that has been decided in a way that we haven't appealed, and we don't appeal it for various reasons. Right. So it doesn't arise today. There were a number
Okay.
of issues raised at first
Okay.
instance, but this is the only one for today. So
Sure.
the
So the
exercise of the power is not
is
not
not
at
an issue.
play.
Thank you. That's very helpful. So it's basically my questions 1 and 3, which we're debating.
Well, we do say there is a fourth question,
What's
which
that?
is not should we leave it to the legislature, because I say that is a question that goes to the construction to an extent, because it's an answer to the policy.
Sorry, should we
considerations.
intervene or not?
Should we intervene or not
I-
is part of the construction issue, I think I would suggest. So it's a question of saying, obviously, this court cannot intervene in the sense of creating a freestanding jurisdiction of its own devices. Nobody's suggesting
No,
that.
no,
It has to come from the judicial
forgive me.
authority.
Forgive me, I actually think it is simpler. The first question is construction. If you win
Yes.
on that, that's the end of it. As though Sullivan's out and you win. But if she wins on that, and if there's no issue as to discretion or power, because you've told me that, you're not appealing that,
Correct.
then we've got a decision where an injunction would have been granted, all other circumstances, but there's Sandra Holding in the way. So
Yes.
are we going to do anything about it? And that raises questions about the limits of judicial development of the law and stare decisis.
Correct. Yes, and I don't think there's anything between us. It's simply how we characterise the issues. The stare decisis issue is absolutely issue number 2. What I would say. So issue 1 is construction. Issue 2 is stare decisis. Absolutely. I think where we differed slightly was the characterisation of the question: should we do anything about it or leave it to the legislature? And that we say it affects both sides of it, but the limits of the judicial intervention. The degree to which the court is willing to strain to construe a piece of legislation are affected by that issue as well, we would say. But in other words, the way I'd put it is like this, and I do take issue with the idea that in Sandra Holding the Court of Appeal didn't deal with issues of policy, because the point that was being made there, which we would endorse, is there may be very strong policy reasons for the law to be different, but what we have to do is apply the law. And so it's about where are the limits of that? Where are the limits of the straining that can be undertaken to interpret a statute in a way that we think is consistent with policy? And that could be characterized as in any event. I'll deal with it, and you will no doubt decide the area that it is relevant to. But I do make that point.
But it's basically 2 questions: construction,
yes,
and stare decisis.
Correct.
That's it.
Correct. So I'm going to take those in turn, and in dealing with the first question, I'm going to break it down, if I may, and I'll break it down as follows. So I'll summarise it first, and then I'll go through the points. So the first point is, as a matter of language, we say, when we look at the enforcement provisions, the enforcement gateways that are being relied on, we say they only respond to an existing judgment. They don't respond to this sort of claim. That is a short point. I won't spend too much time on the language. I don't accept that my interpretation is, as was my learned friend described, as facile. And in fact, it's consistent with the way that equivalent provisions have been interpreted by the highest courts of the UK and also by courts in Jersey. And I'll show you that. But it's also that's the first point, and in a sense that's the beginning and the end of it. But there is more, I'm afraid. The second point is that this has now been the decision in 2 prior Court of Appeal decisions in this court, we say. So the first is Akhmedova, and the second is Sandra Holding itself. Now, that I make that point independently of the stare decisis point, but those are authoritative explanations of the plain meaning of the language in these particular provisions. That's the second point. The third point, and I've trailed this already, is that approach to construction that I'm arguing is wholly consistent with authority from other parts of the Commonwealth on similar provisions. Firstly, Lord Nichols himself, on whom the appellants rely so much, agrees with my construction of the equivalent English rule. and I will show you that. The majority in the Mercedes-Benz case also agreed and said it was a very short point, and they dealt with it in 2 paragraphs. The UK House of Lords in the Masri case, Masri number 4, wasn't dealing with quite the same question, but did approach the question of construction of the enforcement gateway under English law. And I'll show you that, and it is consistent with my interpretation. It is not consistent with my learned friend's position. And there is also the Jersey case, which I rely on, and that they apply my construction, not my learned friend's construction, even when they departed from the Susquehanna on the question of power and when there was a power to grant these sorts of injunctions. Now, this particular argument on similar equivalent legislation has not been considered directly in all the Commonwealth jurisdictions. This has always been the secondary argument that's put. The primary argument on territorial jurisdiction has always been the injunction gateway, and I'll show you those in a moment. But in the other jurisdictions, they have always, where they've said there is no territorial jurisdiction, even though we accept that there is a power if there is territorial jurisdiction, those conclusions are all inconsistent with my learned friend's case, that somehow the enforcement principle and Lord Nicholson's decision and Convoy and Broad Idea are somehow change everything and show you that there must be territorial jurisdiction. They're also inconsistent with the arguments from policy that there's some general international consensus that the court must exercise territorial jurisdiction in cases like the one that we have today. So I'll take you through a few of those. They're relatively short passages, but there are a number of them, and we'll have to go through them. That's the third point, then, that there are other decisions from other jurisdictions that we can rely on. The fourth point is dealing with this submission that this conclusion is somehow undermined or contradicted by the Privy Council's decision in Broad Idea. We say that is simply wrong, and that is partly the result of the use of the term the enforcement principle, because the enforcement principle doesn't mean that an injunction, a freezing injunction, is enforcing anything. It's not the same thing as the claim which will lead to the judgment, which the freezing order will protect. And actually what we say is that the appellant's case is contrary to Broad Idea, both on the principle that the case developed, which was about the juridical characterization of a freezing order, and also on the narrower point that territorial jurisdiction somehow, the decision on that and the interpretation of gateways is somehow affected by the outcome in that case. So we say that the appellant's submissions on all of this, they're infected throughout by a failure to distinguish between those two key questions, territorial jurisdiction and power. That distinction was completely lost in my learned friend's first skeleton. It's now accepted that Broad Idea is about power, not about territorial jurisdiction. But the consequences of that, we say, are not followed through in the argument. So I will deal with that question. Does Broad Idea change everything? Or is it actually, as I say, consistent with me and not consistent with my learned friend? The fifth point that I want to make is to deal with this submission, or the sense that there is some groundswell of international criticism of not taking jurisdiction in these sorts of cases. We say that is simply wrong. And again, it confuses power with territorial jurisdiction. And actually, when one looks at the commentary on the territorial jurisdiction issues that were decided broadly, in a sense, in my direction, those are not criticised at all, and they are found to be really unexceptionable, and it's difficult to take exception with them. That's the fifth point. And then the sixth point, it was going to be my point about judicial legislation. How far should the court go in straining to interpret legislation?
You assume straining.
I assume straining, of course. Yes. And that's my sixth point. And you may have decided I'm wrong, and the language is completely against me, and that's a whole other question. And so some of these are interdependent. Absolutely, I accept that. So my first submission, though, starts with the language of the statutes. Now, but in my learned friend's submission, she asks you to start from what I would suggest is the wrong end. So for example, in her skeleton argument, she says, paragraph 6, she says, if jurisdiction came from the service rules, then there's no doubt the DIFC court would follow broad idea and conclude that the court has jurisdiction. And so she says, well, the question you have to ask yourself is whether you should cut down that jurisdiction by interpretation. And we say that is to take it backwards. The question for the Court of Appeal is not that. It's, as I say, just what does the legislation mean? And that's how other common law courts have approached those two questions, dividing it up in that way. So let's start with Article 24, if we may, of the court law. I'm not going to take you to 5A1E because it doesn't say anything of relevance. It just points you to the other provisions. So page 104 is where we start this exercise. And it's Article 24(1), ratification of judgments. Now, what we say, this confers jurisdiction, and it says some words that don't matter, and I'll try and focus in the words that really do. The court of first instance has jurisdiction to ratify any judgment, I'll come back to order, of any recognised foreign court. So that is what's being relied on effectively. Now, there's two short points in relation to that. And the question very starkly is, does this make these current proceedings, do they fit the description? Are the proceedings before this court within the scope of that description? The court of first instance has jurisdiction to ratify any judgment of a foreign court. So we say, firstly, there is no judgment, there's nothing to ratify, and a future judgment is not a judgment, it doesn't exist. But anyway, secondly, this is a claim for a freezing order. That is not a claim to enforce a judgment. And so it doesn't fit, we say, within the plain words of this provision. Now, my Lord Sir Peter Gross asked the question, well, what about orders? You've got a freezing order from the Hong Kong courts. Now, no claim is made to enforce the order of the Hong Kong courts. That claim has not been advanced. It's not before you today. And to date, it's never been suggested by the appellants that an order of a foreign court of that sort is capable of enforcement under these provisions. That is a wholly different debate to the one that we've lined up to have today. The DIFC court in the past, from cases such as DNB Bank, has always treated the enforcement of foreign judgments as equivalent to the approach taken in the common law. Now, across the world, the common law takes, to some extent, varying approaches to the sorts of order that they will enforce. But the way in which it's been approached in the DIFC court is to take what I would describe as sort of orthodox mainstream English approach. And I know they do this differently in Australia to an extent, which is that it's only money judgments which are enforceable and only final money judgments which are enforceable. Now, in Australia, as I understand it, and I'm not going to teach Australian law to those present, but my understanding is that is slightly different in that injunctions may be enforceable in certain courts. That is not the approach that's been taken in the DIFC court, but I don't understand even Australian law to go so far as to suggest that interim remedies, such as freezing orders, are themselves directly enforceable in the Australian courts. But as I say, that is not the nature of the claim that you have before you today. The nature of the claim you have before you today is simply and purely, does this court have authority to decide a claim for a freezing injunction in support of a foreign set of proceedings? Even if I was wrong about imagine that order did include interim freezing orders and so forth, would that support the interpretation? That seemed to be the suggestion from the bench. I would suggest it doesn't do that at all. It does the opposite, because what it's then doing is providing an answer to all the policy considerations that there are today. So it's I don't propose to engage into that debate in any detailed way. You don't have the panoply of authority that would be required to look at those difficult issues. But what I do say is that those words cannot support the broadening out of the jurisdiction beyond the plain words of the statute. Now, I'll show you how those sorts of words have been interpreted in other courts in due course, but just to go on to page 127, which has the Article 7.6 provision, which is the other one that's relied on. And you will see there, this refers to the execution of judgments. Now, this isn't in terms of the court has jurisdiction too, but it's already been said that it does confer jurisdiction to do the things that are identified in 7.6. And that simply says that judgments, decisions, orders, and ratified arbitral awards rendered outside the DIFC by any court other than the Dubai courts shall be executed within DIFC in accordance with the procedure prescribed in the rules of court. So again, the 2 points are, it says judgments shall be executed. There is no judgment, and the claim is not for the execution of a judgment. And so again, on a what I would suggest is a free reading, leaving to one side all the questions of policy and all the rest. On the free reading, we say the inevitable interpretation of the language of this is it does not cover the claim that we're looking at. Now, I will build on that, but in a sense, we say that is the beginning and the end of it. And it does require straining, we would say, to include within the scope of the descriptions that are identified here, a claim of this sort for a freezing order in support of a prospective judgment. And whatever the pros and cons of that result. And I'll just deal briefly with one point that my learned friend made in her submission. She said, well, it must be broader than that, because how else, if you have a judgment, can you get a freezing order in support of a judgment? But that is not the answer to the question. That doesn't challenge, doesn't contradict my construction, because it's quite clear that what these gateways do is they define descriptions of claims which may be brought, and if your claim fits within that description, which it will if you have a judgment, a claim may be brought, and then in that claim the court may make orders and applications may be made, and orders may be made against the parties from all kinds of orders. Orders to produce witness statements, orders to make disclosure, and some of those may be backed up with injunction-like sanctions, and have warnings that if they're breached, then there will be a contempt. So,
Mr. Montague-Smith, I'm sorry to interrupt. Do I understand you to be saying that then that there will be no circumstance in which the court may grant a freezing order in support of a prospective judgment?
No, I'm not saying that. So what I'm saying is that claim in and of itself does not enliven the jurisdiction of the DIFC court. And when I say jurisdiction, I mean territorial jurisdiction. Yeah. So if, for example, I was to bring a claim against the DIFC establishment for a prospective, for a freezing order in support of foreign proceedings, then the DIFC court would have territorial jurisdiction, and it would have, broad idea, enforcement principle approach, the power to make a freezing order in those proceedings. And there are other gateways within Article 5A, which might be enlivened. So if we go back to page 124, the one I've described is 5A1A. Now, you can see there might be claims, 5A1B, for example, civil or commercial claims or actions arising out of or relating to a contract or promise contract, whether partly or wholly concluded, finalised or performed within the DIFC, or will be performed or is supposed to be performed within the DIFC. So you might have a contract which fits that description, but which is being litigated in another forum for one reason or another. Perhaps there's a jurisdiction agreement in favour of that forum. But you may well be able to persuade the DIFC court that nevertheless, your claim for a freezing order in support of that prospective judgment falls within 5A1B. Now, that might be met with resistance. It it might not be the conclusion, but one can see that there is definitely an argument in relation to that. And similarly, 5A1C. Now, D is specific to the DIFC's jurisdiction. So no, there aren't. And what 5A1 does is it's defining, or A to C at least, is defining a sort of necessary factual nexus that's required before the DIFC court's going to get involved in the dispute, before the DIFC court's going to superimpose its rules, its laws, onto parties and disputes which might otherwise have nothing to do with this jurisdiction. So that's not the logical interpretation conclusion of my construction at all.
However, forgive me butting in as well, but I may as well. Let's assume that there was a judgment in Hong Kong.
A final judgment?
Yeah.
Yes.
That your client had removed X million unlawfully.
Fine.
Would it be possible to obtain the freezing order in this case?
Yes. So in that case, because so if it comes within Article 24 of the DIFC
yes.
court law. So we've got Article 5A1E, which we see on the top of page 125. The court has jurisdiction over any claim or action over which the courts have jurisdiction in accordance with DIFC laws. And then we go back to Article 24, which is at page 104. And that requires, as I say, that requires a judgment. But once you've got a judgment, there's no problem with bringing your claim. And
so everything.
Sorry.
Yeah, you go on. My fault.
So then you've got a claim. So what are the court's powers that are associated with that claim? Those arise under Article 22 and 32 of the court law, which confer powers to grant, very broadly, grant injunctions.
So, stripping it down to its essentials, everything turns on judgment.
Correct.
That's it. So
well,
if we either can or can't read judgment, has extended into prospective judgment.
Well, but yes, I agree. That is the question.
Nothing to do with anything else about the nature of a freezing order, anything else. Well, it all comes down to this rather brutal question.
I agree.
If you're right,
yes,
that's it. And if you're wrong, that's it as well.
I agree. So the question that's been asked is, does it come down to whether or not judgment includes prospective judgment? And we would say we would say it plainly doesn't, because a prospective judgment is not a judgment. It's not something that exists. So, future children, a claim by a future child doesn't have any meaning. Future things don't currently exist. They cannot be enforced. And there's another part. I mean, you can characterize it in a slightly different way as I do, which is to say, does the claim that is being advanced fit the description of a claim to enforce a judgment? And the claim, and as we'll see, a freezing order is not an exercise in enforcement of anything. It's preparing the ground for enforcement. I'll come back to that in any event. But yeah, that is absolutely the stark question. And the way that I approach that, as I summarised, is to first show you how it's been approached in the DIFC courts, then take you to some of the equivalent questions in foreign jurisdictions and run through them. So the first one is Akhmedova and paragraph 303, sorry, page 303, and paragraph 21. And I'm just going to read this very quickly, if I may. It said, this is the Court of Appeal. In our view, it's manifest that the jurisdiction of the court to enforce a foreign judgment is limited to those parties against whom the judgment has been made. Who those parties are will be discernible from the judgment itself. To extend jurisdiction to a party against whom a judgment was not made on the basis that, although he possesses or it possesses juridical personality, he or it is to be equiparated with a party against whom the judgment was made, would be a significant development in the law of the DIFC and would be at variance with the doctrine of obligation that underlies the court's jurisdiction to enforce foreign judgments. So just pausing there, that reference to Barclays Bank and SR Global, that was where Sir Richard Field had confirmed that the DIFC court takes a similar approach to the English common law. And effectively what it does is it understands a foreign judgment as creating a debt. And that debt is a debt that can be recognised and enforced in the DIFC courts. It creates an actionable obligation to pay. And so what the Court of Appeal is saying here is a third party to a judgment is not under any actionable obligation to pay. And as a result, the jurisdiction does not arise. And you can see that from paragraphs 20 above, what was being argued there, it was being argued that this third party, which was said to be the alter ego of the judgment defendant, that the injunction could be advanced against them under the gateways that are relied on today. So what the Court of Appeal goes on to look at, though, here, if we carry on from where we were, they say, we are accordingly of the opinion that if the legislative intention had been to extend jurisdiction in this way, the legislation would have clearly so provided. And in the absence of an amendment to the legislation, the court does not have jurisdiction over a party like Strait, who is not a party against whom a foreign judgment was made.
This was in the context of a case in which there was a judgment.
Yes, but there was no judgment against this particular defendant. But that changed during the course of the proceedings, as we see from paragraph 22. Ever since the respondent came to know about the transfer of the Luna, this is the ship that was sought to be attached, into the name of, or frozen, into the name of Strait, it was open to her to apply to the English court to have Strait joined as a party against whom the judgment for the payment of £350 million would be made, thereby establishing jurisdiction over Strait in the DIFC courts. This indeed is what she proceeded to do, with the result that on the 19th of April 2018, Mr. Justice Haddon Cave ordered that Strait be joined as a party to the English ancillary proceedings so as to make Strait directly liable on the English judgment. It therefore only remains for the respondent to obtain the leave of the DIFC court to amend her pleadings to reflect the fact that Strait has been made a party to the English judgment for jurisdiction to be established over Strait in accordance with the relevant legislative provisions concerned with the enforcement of a foreign judgment. So what they said was, firstly, you cannot found jurisdiction until you have a judgment against that particular party, and that there was a judgment, but it was against another party. But there was no judgment against Strait, and that changed in the course of proceedings. And we see in paragraph 22, until 19th of April 2018, the claimant had a good arguable case that Strait would be in due course a judgment debtor. On that date, Strait is joined in England, and now there is a judgment against them, and they are a judgment debtor. Before that date, there's no jurisdiction. After that date,
isn't the question in this case, though, whether there's a power in the court to grant a freezing order in order to avoid the stultification of a jurisdiction which it would have to enforce a judgment against an identified party?
Well, we say that then is to take the question the wrong way around. That is to expand the scope of the jurisdiction to meet
it's a question of power, isn't it?
To match the scope of the
power
power
in aid of that prospective jurisdiction.
There is power, yes, there is power, but that does not answer the question of whether there's jurisdiction. The question of whether there's jurisdiction is answered by whether or not the claim for an injunction matches a description of a claim over which the court has jurisdiction. And
the court has authority to decide a case involving a foreign judgment in which enforcement of that judgment is sought before the court. And the question is, isn't it, whether the court has power in anticipation of such the exercise of that jurisdiction to prevent it from being stultified. Really, it's like the Bayan case, isn't it?
Well, I mean, I can come on to Bayan, but I will deal with that in order. But what this court needs to ensure it's not doing is coming up with arguments which assume the conclusion. So in other words, if the scope of the court's jurisdiction is defined by Article 5A1A, 5A1 and 24 and so forth, then we just need to read those articles to see what the court has territorial jurisdiction to do. Saying it has powers, and those powers will be nullified and stultified and so forth if we don't have jurisdiction, territorial, in a particular case or other, is not the answer. What that is doing is that is looking at policy questions.
So, I don't think that's the right characterization of what I'm putting to you. What I'm putting to you is the court has jurisdiction to enforce a judgment out of a Hong Kong court against an identified party. There are pending proceedings. Hong Kong has made freezing orders of its own, not suggesting that they're being enforced in this court. The question is whether this court, in anticipation of the exercise of that jurisdiction to enforce the Hong Kong court, may exercise a power to make a freezing order so that the enforcement responsibility which it may have to exercise is not stultified. So it's talking about a power in aid of a defined jurisdiction.
But all right, but then that understand. I mean, we in my submission that mixes up again, that crosses over, cross-fertilizes questions of power and jurisdiction. The question has to be, firstly, is the enforcement jurisdiction enlivened before there is a judgment? Because your Honour's starting point was the court has jurisdiction to enforce a judgment that comes out of the Hong Kong courts in the future. But the question is, when does that jurisdiction arise? Because the court does not, we say, have jurisdiction to enforce a judgment coming out of the Hong Kong court. Why not? Because there is no such judgment. It doesn't meet that description in Article 24. And that... Sorry, I'm being interrupted.
Yes, I'm probably interrupting you. Sorry. It's a question really of how you approach the construction of judgment.
Yes.
If you look at it literally, then I follow without expressing any conclusion what you're saying. If, on the other hand, you look at it in its overall context, or purposively, then it might be said that your argument struggles rather more.
I understand.
I don't think attaching labels to it, like conflating powers and jurisdiction, really helps on this. Well, I think the question is, forgive me, what does judgment mean, and how does one approach its construction?
I fully understand that point, but that's the point that I was trying to make to Justice French, that is ultimately an argument that comes from policy. It's ultimately said.
But
and I'll come on to that.
All construction takes context
yes,
into account.
Of course. But the context here, there's no real debate about what the context is. There's no linguistic context that we're talking about here. The context is that it's a jurisdiction, or sorry, a provision which creates jurisdiction. And there will be questions about whether you should read that broadly, whether you should read that expansively, or whether you should read it narrowly. And that's why I say it ultimately comes down to a question of policy issues about how one approaches those sorts of provisions. And that's why I was going to show you how the other courts around the world have approached it. Because if the view is, well, we look at jurisdiction provisions expansively, that is out of step. That is out of step with international consensus. That is absolutely not how jurisdiction provisions are approached, for example, in England and Wales, where quite the opposite. Because the way in, and I'll come on to all of this, but the way in which the English courts approach it is to say, well, the starting point is we are being asked to tell somebody what to do who isn't in our territory, who isn't being told to do anything in our territory. We're telling them to do something outside our territory or not to do something outside our territory. So in this case, we're dealing with a freezing order that it's not about anything going on in the DIFC. And so in England, they say, well, actually, the court needs to be very careful about expanding the boundaries of those sorts of things. And these exact same sorts of arguments come up in Convoy, Broad Idea, and all the cases that led up to it, because in those cases, the injunction gateway, which there was one, was provided for jurisdiction in respect of injunctions to do things or not to do things within England and Wales. And so the question was, does that include freezing injunctions? And you'll see the literal interpretation, which was relied on by Lord Denning in the Susquehanna in the Court of Appeal, was, well, a freezing injunction is just an injunction. So on the language, it falls within the provision. But they said, no, 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 you have to see what this is all about. This is all about jurisdiction. We're talking about substantive claims, and it's not right to make an expansive interpretation of that. So that's it. We would so I think the first point I was simply making was just on the language, and I'll move on to these other considerations in a moment. But on the language of that, when the legislation talks about executing judgments, enforcing judgments, the jurisdiction of the court has jurisdiction to enforce a judgment. One has to ask oneself, we say, is this a claim to do those things? And on the language, we would say it's not. Even if you can say a judgment is a future judgment, there is no claim to enforce a future judgment in these proceedings. So I would suggest that on a literal reading of the statute, it's difficult to see how one can put a claim of this nature into that box. Now, I accept that that's not the end of it. In a sense, it is, but there are other considerations to consider, and the other considerations is start, I would suggest, with looking at how similar legislation has been interpreted in other jurisdictions, because there are these points have been made in other jurisdictions. Now, of course, the specifics of the arguments and the conclusions in those cases can turn on the precise terms of the rule that is being applied. What is the scope of the territorial jurisdiction created by that rule? And in some territories, you've got those rules set out in statutes, but in England and Wales and the courts which have followed it from the Commonwealth, they're based on the service out provisions. Rather anomalously, those aren't even in court rules anymore, they're in a practice direction. But the point is that they set out a number of numbered gateways, and the rules they're not the same as the DRC, but we would say that the enforcement gateway is materially the same. The language is materially the same. So what I was going to show you, because it's helpful to, when we're looking at the Commonwealth authorities, is to show you the rules that have been looked at in those other cases and make that good. It's page 179 is the practice direction in England. And this shows you the shape of the current rules. And so you'll see paragraph 3.1 is where you get the beginning of these gateways. The claimant may serve a claim form out of the jurisdiction with permission of the court under Rule 636 where, and then there are a series of descriptions of claims which in relation to which there can be territorial jurisdiction. Now, these have changed fairly recently and have been expanded out pretty significantly. But the ones that we are concerned about today did not exist. The enforcement gateway did not exist at the time of the Susquehanna, but it came in by the time of the Mercedes-Benz case. I'll explain that as we go through it, but it is useful just to get our bearings in relation to this. If we go over the page, you will see, firstly, at paragraph 2, the gateway which was primarily relied on in the Susquehanna, Mercedes-Benz and Convoy, and the one which was not revisited in Convoy, which is number 2. The claim is made for an injunction ordering the defendant to do or refrain from doing an act within the jurisdiction. That was relied on in the Susquehanna. The one that is similar to R1, the DIFC's one, is at 10 at the bottom of this page. Enforcement. A claim is made to enforce any judgment or arbitral award. Now, so what I say is that is materially, therefore, the same shape as the gateway that's being relied on today as giving territorial jurisdiction to grant the order that's being claimed. In between these, you will see at paragraph 5, the one that was inserted to resolve the territorial jurisdiction gap, which was confirmed as existing in the Susquehanna. So that is a claim is made for an interim remedy under section 25(1) of the Civil Jurisdiction and Judgments Act 1982. Now, that's the provision which confers express power to grant an injunction in support of foreign proceedings in certain circumstances. So that's the source of territorial jurisdiction for a freestanding freezing order in support of foreign proceedings in the UK. England and Wales. That's the position as things currently stand. Now, as you would expect, that provision did not exist at the time of the Susquehanna. It was introduced after that to resolve that problem, but it also doesn't exist in certain other jurisdictions where the similar issues have arisen, because they didn't introduce similar legislation. They started from the original court rules, and so the original jurisdiction position as there was in England. And but what is interesting is to look at the question which has arisen, which is where that gateway didn't exist, either because we're talking before it was introduced in England, or we're talking about a jurisdiction where it was never introduced. Where that jurisdiction didn't exist, could jurisdiction be established under one or other of these other two gateways? And we can trace this through how it was approached, starting, if I may, with the Susquehanna. And this is, we've got to look at a number of different cases, but not a lot of them. So hopefully this exercise won't take too long, and I won't try your patience too much. But if we go to page 627, you can see F there. The issue that was being argued was that the injunction gateway covered, in effect, a freezing order, because it's an injunction and that's what it said. And you see at 258F, finally, I should say a word about those policy considerations that led Lord Denning MR to the conclusion that even if the rules of court do not now provide for it, the judges ought to be bold enough themselves to extend the jurisdiction of the High Court to authorise service of its process on persons out of the jurisdiction, either one, so as to enable and merits and so forth. So the argument was that a claim for a freezing order is a claim for an injunction to do or not do something in England and Wales. The Court of Appeal and Lord Denning had found that it was, as a matter of language, supported by policy. And Lord Denning had concluded that that was the right conclusion, and the House of Lords in the Susquehanna disagreed. And so you see the argument over the page. I'm sorry, I've taken you to the wrong original page. It was 624 was where we should have started. And it's under F. What was contended by counsel for the cargo owners is that if the action is nevertheless allowed to proceed, it will support a claim for a Morava injunction restraining the ship owners from disposing of their assets within the jurisdiction until judgment and payment of the damage is awarded thereby, and that this of itself is sufficient to bring the case within subrule I, which empowers the High Court to give leave for service of its process on persons outside the jurisdiction, and then recites the rule. So you can see that if the argument was simply apply the strict literal wording of that rule, a freezing order fits within it. And all of the policy considerations were taken on board, and the effect of those considerations was not to say have an expansive approach to this jurisdiction. It was to say actually keep it to the narrow. And that's why I was showing you, sorry, the passage on paragraph at 627F and the rejection of the policy arguments. And if we go forward to page 629, above B, my lords, there may be merits in Lord Denning's alternative proposals for extending the jurisdiction of the High Court over foreign defendants, but they cannot, in my view, be supported by considerations of comity or the common market treaties. That would require at least subordinate legislation by the Rules Committee under section 99 of the Supreme Court of Judicature Consolidation Act 1925, if not primary legislation by Parliament itself. It's not for the Court of Appeal or for your lordships to exercise these legislative functions, however tempting that may be. And Lord Hailsham agreed with that. You see that at page 631 at B, just below A, in fact. The second point upon which I wish to comment is the argument of Lord Denningham, fortified by the authority of a quotation from another case, that the judges need not wait for the authority of the Rules Committee in order to sanction a change in practice, indeed an extension of jurisdiction in matters of this kind. The jurisdiction of the Rules Committee is statutory, and for judges of first instance or an appeal to preempt its functions is, at least in my opinion, for the courts to usurp the function of the legislature. So now these arguments are not looking at the enforcement gateway because it didn't exist at that time, but they are looking at an injunction gateway, which on its literal terms included the sort of injunction that was being sought, and all of the policy considerations and all of the principles of interpretation and construction that are relied on to say we should expand our literal interpretation of Article 24 in this case actually did not have that impact in that case, did not suggest that an injunction in those rules included an interim injunction. Now, in the Mercedes-Benz case, though, the argument that is being put today was squarely raised. If we go to page 643, we can pick up the judgment there. So we're in, by this point, we're in 1995. And by this point, the enforcement gateway is in place. And this was being relied on too in this case, together with the injunction gate. And you can see page 643 in the middle of the page, the reference to the court rules that were applicable. And just underneath C, do you see there, the gateway, which is very similar to ours, is M. So the claim is brought to enforce any judgment or arbitral award. And that is in identical terms to gateway, what is now gateway 10 in the practice direction that I showed you, Your Honours. And you will see on the last line of this page, subparagraph M is a recent addition, so it's been brought in. By now, by the way, the injunction gateway is B. That's the other one that's relied on. You can see that just below B on the side of the page in the quotation. An injunction is sought. That's B in these rules. I draw that to your attention so we can keep track of what's being referred to here. So the arguments for jurisdiction are set out on page 644 at the bottom of the page next to H. Now, first there was an argument about submission to the jurisdiction, so we leave that to one side. But then you'll see just by H, at the end of the line, it says, and second that the court had jurisdiction to grant the Moravian injunction by virtue of subparagraphs B and M of Order 11, Rule 1.1. So that includes both the injunction gateway and the enforcement gateway. And then if we go over the page, 645, 296 of the authority, 645, down at the bottom there, H, is saying the service out rules are not a technicality because they set territorial jurisdiction. So what it says is the court has no power to make orders against persons outside its territorial jurisdiction unless authorized by statute. There is no inherent extraterritorial jurisdiction. It relies on the case of Waterhouse and Reed. Thus, and this is critical because the argument being run is that Lord Nichols' dissenting speech somehow changes the analysis. What Lord Diplock says here, I think, is even if Mercedes are right in their contention that notwithstanding the statements of principle in Susquehanna, a Moravian injunction can properly be granted in support of proceedings in a foreign court, the order cannot simply be made in the air. There must be some means authorized by statute of bringing the person affected before the court. So that observation, it cannot simply be made in the air, that is in essence what we say is the gap left by the appellant's arguments here, because broad idea is really about power. And what the Privy Council is saying here is that even if the power exists, You have to find some source of territorial jurisdiction. And that is to be found in the rules which define the scope of territorial jurisdiction. In that jurisdiction, it was the service out gateways, that was Hong Kong. In our case, we've got Articles 7 and 24. If we go on in this, on the same page down to just below F, the first paragraph, they make the point it's important at the outset to distinguish two questions. The first is concerned with territorial jurisdiction. The foreigner is outside the jurisdiction. The claim against him has no connection with the home territory. No action against him in respect of that claim could probably be brought before the local court. So that's the first question. And then over the page at 647, under A, the second question is concerned with a different kind of jurisdiction, or more accurately, a power. Assume for this purpose that a foreign defendant is someone who can be brought before the English court to answer a claim for a moreover injunction, either because he's present here or because the provision is wide enough to cover all kinds of injunction. Assume also that the matter in dispute has no connection with the English courts, and the plaintiff neither can, nor as in the present case intends to bring them before that court, does the court have power to restrain the free disposition of the defendant's assets, and so forth. So there's a sharp line between what powers the court has when it has territorial jurisdiction and how you answer the question, does it have territorial jurisdiction? And in G, you can see they look at the first question, territorial jurisdiction first. So same page, we're now 647 in the bundle, down at G. It will be recalled that Mercedes rely on two provisions of Order 11, namely subparagraphs B, that's the injunction one, and N, that's the enforcement one. The latter need not be considered at length. And this is where they deal with this question. There's a preliminary point about originating process. I don't take that point, but then they go on to say this over the page at 648. So 4 lines down, and this is quite a critical passage of the judgment. Leaving this aside, however, there are 2 unanswerable objections to a jurisdiction asserted under subparagraph M. The first is that the claim would not be brought to enforce a judgment. Unlike a suit founded on the cause of action created by a judgment, the moreover injunction does not enforce anything, but merely prepares the ground for a possible execution by different means in the future. Secondly, and more simply, in a case such as the present, the injunction does not enforce a judgment, but is intended to hold the position until a judgment comes into existence. At the time when the injunction is sought and granted, there is no judgment. All that the plaintiff can do is to assert his hope that a favourable judgment will at some time in the future be obtained in an action, which at the time when the application is made, may not even have commenced. It is quite plain that subparagraph M was not intended to encompass such a case. So what was described as a facile argument, and what the Sandra holding was, the Court of Appeal was criticised for dismissing this argument in fairly short order, is actually dismissed in fairly short order by the Privy Council in Mercedes-Benz. Now, and they went on, by the way, to consider the injunction gateway and dismiss the assertion that the injunction gateway covered freezing orders. Now, Mercedes-Benz is, of course, the case in which Lord Nichols issued his famous dissent. He dissented on the question of power, and he dissented on the question of the scope of the injunction gateway, but he agreed with the conclusion on the enforcement gateway. We see that at page 661 of the bundle. And it's next to page, so we're now in Mercedes-Benz, page 312 of the report, down by E on the side. It's page 661 of the bundle. The second question, territorial jurisdiction. So he's dealt with his issues about power. And what he says is this: quite apart from the question of power, we need to find territorial jurisdiction. He says, but the first defendant does not live in Hong Kong. He's in Monaco. This fact gives rise to no problem over subject matter jurisdiction in respect of the application for moreover relief. By subject matter jurisdiction, he's talking about what I've been calling the power, and what the other judges called that. There will be no difficulty over the enforceability of the Monaco judgment in Hong Kong in due course, even though the first defendant is abroad. When the judgment is forthcoming, Mercedes-Benz may obtain leave under RSC Order 11, Rule 11M, to serve on the first defendant outside Hong Kong an application to enforce the Monaco judgment. But what about service of the Morava proceedings? The Hong Kong court can only entertain Mercedes-Benz application for a Morava injunction if the originating process falls within one of the heads of Order 11, Rule 1, under which leave may be given for service of a writ outside the territorial jurisdiction of the Hong Kong court. The only head in Order 11, Rule 11 relevant to this application is subparagraph B. This gives rise to a short point of interpretation. So Lord Nichols notes that there is this Gateway M, which allows for the enforcement of foreign judgments. It doesn't even feel the need, really, to engage in a detailed textual analysis of it, to reach the conclusion that it's only the only relevant gateway that could possibly be relied on is the injunction gateway. That is the judgment that my learned friend says, that is the dissent that my learned friend says everything changes in light of this. So that's the Hong Kong position and the unanimous Privy Council decision on the rules, and equivalents of those rules arise in many places. The same point, of course, does not arise in England and Wales in quite the same way, because we've now got this gateway, which I showed you at the outset, Gateway 5, which permits this freestanding jurisdiction to be exercised. But the scope of the enforcement gateway did arise in the Masri 4 case, and this I mentioned in opening. 678 is the page. It arose in a different context. The issue in Masri 4 was whether or not there was territorial jurisdiction over to summons into the court a foreign officer of a judgment creditor. So the position was the claimants had a judgment against an English judgment against a particular company, and they wanted to summons into court for questioning about assets officers of that company. And the UK House of Lords decided that the rule did not extend to non-English, officers who were outside the territory. And by the way, there was no means to establish territorial jurisdiction in relation to them. And so the question starkly was, could those individuals be summoned in? And the answer, as I say, was no. Firstly, it was outside the scope of the rule. But secondly, that it couldn't be served out. Why not? They considered whether an application of that sort to summons in an officer of a foreign officer, if I can put it like that, of a judgment debtor might fall within the enforcement gateway. So not dissimilar to what we're talking about here. We're talking here about orders which are being sought to assist in the subsequent enforcement of a foreign judgment. Does that order to assist in the enforcement, in this case in Masri, an order summoning in people to answer questions, does that fall within the enforcement gateway? And the answer was very clearly no. See paragraph 38. Finally, Mr. Salzedo submitted that all else failing, the case could be brought within one of the heads of CPR 620, that is, at that stage number 9, a claim made to enforce any judgment or arbitral award. In my view, this submission also fails. An application to enforce a judgment within the jurisdiction is distinct from an application to order examination of a witness who is abroad with a view to enforcing the judgment wherever assets may prove to exist. The former does not trespass out of the jurisdiction of the English courts. The latter would, in a manner which was clearly not in mind in 629, and then disregards. So this is an example of the highest courts in the UK rejecting an attempt to read the enforcement gateway in an expansive way to include measures that you might want to adopt to help you enforce a judgment in future. That is not the enforcement of a judgment. So that's the we would say instructive. It assists you to understand what is meant by this gateway. You would have to take a very different view of the language and function of the gateways in this jurisdiction than the UK House of Lords took, than the Privy Council took, than is taken in Hong Kong. We obviously the issue has been raised of the case. I'm going through the bundle in the order that the judgments come, and they're grouped by jurisdiction. But the case that's obviously been raised is the PT Bayern Resources case, and that is one with which two of your lordships are, your honours are very familiar, and it appears, I think, at page, is it 953? Now, sorry, that's the section that I was going to show you. There are questions here, and I hesitate to instruct you in what the meaning of this judgment is, for obvious reasons. But what I would say is, firstly, the reason I had myself alighted on passages from this was that because it indicated to me that it supported me to an extent in my construction of what was required to meet this enforcement gateway. Page 953 recites the test by which the court decides whether or not to enforce a foreign judgment. And thank you. And the test requires, so it says, a judgment creditor under a judgment to which this part applies may apply to the appropriate court at any time within 6 years after the date of judgment, and so on. And if we go over the page to paragraph 28, as I understand it, Chief Justice says, obviously, no application can be made under Article 6(1) until such time as a foreign judgment on which Part 2 applies comes into existence. So we had taken from that the four corners of that provision, Article 6, cannot be enlivened. They're not. If that's where jurisdiction, that's the source of territorial jurisdiction, then that provision doesn't get you there, because you can't meet the test until you have a judgment. Now, I accept that the court went on to find that it did have authority to decide in that case. I had understood that to derive from a different source, and actually the answer stated in paragraph 2, 948. Page 948, paragraph 2, the answer is that the Supreme Court has that inherent power within the authority to adjudicate conferred on the Supreme Court by section 39(2) of the Judiciary Act 1903. The exercise of that power is regulated by the Supreme Court rules. And that position is set out pages 957 and onwards, and relies on, as I'd understood it, the inherent jurisdiction derived from those powers. Now, nobody suggests that the DIFC court has a similar sort of inherent jurisdiction. Nobody suggests that the source of the Australian court's jurisdiction is in similar terms to the DIFC legislation. And so if the short question is one of construction, what is required for a claim to enforce a judgment? The answer, we would say, is supported by the conclusion of paragraph 28, that it's obvious that you first need to have a judgment. Now, it may be that I'm wrong about all of that, and that I am wrong in my construction of this judgment. And actually, the court was saying, one way or another, we can derive our territorial jurisdiction from a rule which talks about the enforcement of a foreign judgment even before you have a foreign judgment. If that is the position, we would say that that conclusion is out of step, actually, with the rest of the Commonwealth, because you've seen what they say in the Privy Council, which will govern the Commonwealth position. You've seen that that was specific to Hong Kong, but I'll come on to some other situations. And you've seen what the UK House of Lords has said, and I'll show you what they say in Jersey. If we can go, please, to page 1005. This was exactly the same, effectively the same question. I may have the wrong. Yes, sorry, 1006, that's it. The issue, again, was whether or not they had territorial jurisdiction, regardless of whether they could exercise the power to grant an injunction in support of foreign proceedings. And the problem arose because the injunction was being sought in part against Lawrence Graham, who were solicitors. They'd received certain funds. And so it was a claim for an injunction in support of proceedings which were not taking place in Jersey, and also against a party who was not present in Jersey. So the court says at page 1006 of the bundle, paragraph 5 of the transcript, line 5, we turn now to the question of territorial or personal jurisdiction. And then they note the submission of Lawrence Graham that there's no jurisdiction. And then what they do at 15 to 30 is recite the particular provisions that are relied on. So firstly, you will see at row 20, the injunction jurisdiction, the injunction gateway is relied on. Secondly, at line 25, there's a necessary and proper party gateway that's relied on. And then finally, at line 30, just beneath it, the claim is brought to enforce any judgment or arbitral award. And so they go through each of these and they deal with the final one first. You'll see that at line 45. The present position is that the plaintiff has obtained a final judgment against the defendant on liability. The damages payable, if any, have not, however, been quantified. The question is therefore whether the claim in the order of justice is brought to enforce the arbitral award. It seems clear to us that the answer is no. At present, there is nothing to enforce. The claim is brought to obtain security over the page for the payment of any damages which may ultimately be awarded. Rule 7M cannot therefore justify the service of proceedings on Lawrence Graham. So the point in that case, and the point in that case was that there was a judgment, but it was only a judgment on liability. And so there was not yet any judgment on quantification. And that liability judgment was not sufficient to enliven this gateway either. And one can see that an expansive...
Well, we're not bound by that decision, are we?
I'm not suggesting you are. I'm not suggesting you are. But what I'm showing you is two things. Firstly, the weight of authority, we would suggest, supports the conclusion that words of this sort do not extend to future judgments. And then it'll come at the end when we deal with stare decisis. But this is also relevant to the question whether or not another court, a prior court of appeal, has come to a decision which is tenable, which I would suggest is the test as to whether you interfere. But I'll come back to that.
There are perhaps two slightly separate questions. One is how the wording in difference has been interpreted.
I'm sorry,
the second question
I lost you there, my lord.
I'm so sorry. Can you hear?
You broke up. Sorry.
Can you hear me now?
I hope so.
Can you hear me now?
Yes.
I'm sorry if.
No, not at all.
The first is the interpretation of the wording in different rules. The second is the international position today as to granting freezing orders in support of prospective judgments. We probably have to consider both.
Yes. But I think one has to consider, obviously, the first. And yes, of course, as I acknowledged at the outset, the language is not identical. But unless we would say there are material differences, these sorts of considerations are, I would suggest, relevant and potentially persuasive. In relation to the international position today, it's important to recognize how that was arrived at. And so, and it was not by an expansive interpretation of jurisdiction provisions. It was by targeted specific legislation, firstly in the UK, and then in a series of other jurisdictions. So when we come on to Convoy and Broad Idea, the position is that there was the power to grant a freezing order, but there was no territorial jurisdiction in relation to one of the defendants because there was no equivalent to that legislation. So that's a very recent example of a jurisdiction which didn't have that legislation. So there's no international consensus that you need this legislation, or indeed, and we would say, if you're going to get there, it needs to be in a law. I was going to show you very briefly one other authority before I move on, if I may, and that is the decision of the Cayman Islands in VTB Capital. Now, I'm afraid that the report of this is not the easiest to understand, but if we go to page 1050, I will hopefully be able to guide you through it. This is a decision, I think the leading judgment was given by Lord Justice Chadwick, who obviously was a former Deputy Chief Justice of this court. And again, you have a situation, this time in Cayman, where what is being sought is a freezing order in support of foreign proceedings with no judgment yet available. And again, you see at page 1050 at the bottom, the final two lines, the relief, the only relief now sought on this appeal is a declaration that the Grand Court has power under, and this is Rule B, to permit service of the writ of summons filed in these proceedings out of the jurisdiction. So that was just based on the injunction gateway, not on the enforcement gateway. And what happens in this case, if you can see it at page 1055, is that the court acknowledged that things had moved on since the Susquehanna, and that Lord Nichols' view about the sort of juridical nature of a freezing order and the power issue were to be preferred. And that was now the rule of the land in the Cayman Islands. But then they nevertheless applied the approach in those cases to territorial jurisdiction, which had been agreed by the majority. So you see that at page 1055, paragraph 25. As I have said, the question whether a Moreover injunction can be granted in aid of foreign proceedings is settled, at least at the level of this court, by the recent decision of this court in Feldhoff. It is recognised that such an injunction can be granted. But should this court take the next step of declaring that proceedings can be served on a person who owes no allegiance to this jurisdiction and is not present in this jurisdiction, simply in order to enable such an injunction to be granted? That's effectively, as I understand it, the sort of thrust of His Honour Justice French's position. You effectively, if you have a power but no jurisdiction, aren't you? Doesn't power effectively demonstrate that you must have jurisdiction, otherwise you can't have the power. And paragraph 26, given the developments in the law since the Mercedes case, including in particular the recognition in this jurisdiction, notwithstanding the decision in the Susquehanna, a Moreover injunction can be granted in aid of foreign proceedings, it's tempting to take that step. But to my mind, that temptation must be resisted. The step is a step too far for the court to take. This court must, in my view, follow the guidance given by the majority of Mercedes-Benz in the final paragraph of Lord Mustall's opinion. Addressing this very question, he said, that if the position were reached, as it has now been reached in this jurisdiction, the Moreover relief can be granted in support of a claim pursued in a foreign court, and the question of whether or not the rules should be extended to enable service out of the jurisdiction on a defendant to such a claim should merit close attention of the rule-making body. And for all the reasons which have been explained in other courts, that may well be a desirable step to take, but it is a step which should be taken by the rule-making body or perhaps the legislature in this jurisdiction. It is not a step which, in my view, is open for the court to take. This court must apply the law as it presently is in the light of the decision of the Privy Council and Mercedes-Benz. And that was the decision, not on the power, but on the service out rule, so on the territorial jurisdiction point, because by this point in the Cayman Islands, the power issue does not follow the Susquehanna. So the question, and Cayman Islands is not alone in being a jurisdiction which decided not to follow the Susquehanna and preferred the analysis of Lord Nichols in the Mercedes-Benz case. And the most notorious case, perhaps internationally, of that happening is the Black Swan case in the British Virgin Islands, which created a lot of storm. But that tells us nothing about territorial jurisdiction. Neither does the Solverlug case that my learned friend referred to from Jersey tell us about territorial jurisdiction, because that's all about the power. Because, why? Because they were dealing with local parties. So BVI concerned local parties. And so the the question then becomes, well, is this all affected by convoy and broad idea? Does this change? As my learned friend says it does. That's her primary point in her case. And she relies on that for two reasons. one, to show why Sandra Holding was wrong, and two, to show why you should go back and look at it again in light of broad idea. Now, in convoy, both of these issues arose, so both issues, power and territorial jurisdiction, arose in relation to one of the defendants. That was Dr. Cho, who was the shareholder of the company, broad idea. And the reason it arose was because the company was a BVI company, so there's no question of territorial jurisdiction. And the BVI, and the Privy Council found that the Lord Nichols was right, and the power existed to grant an order against him, against the company, restraining them in support of foreign proceedings. But the problem, the territorial problem, arose in relation to Dr. Cho, because he was resident in Hong Kong, and so there needed to be both the power and the territorial jurisdiction. And the argument that was run, and you can see it if we go to page 28 of the bundle. You can see it at H of the transcript, which records the arguments of the parties. The argument was run that, firstly, Lord Nichols is right about the power issue. And secondly, once you recognise the true juridical basis of a freezing order as explained by Lord Nichols, then that means you can change the answer in relation to the territorial issue, because it causes you to reinterpret the scope of the injunction gateway. And so you see that being argued out at H and over the page to A, and don't need to go through it, but that's the point that was being made. And what happened was that the board refused to entertain the jurisdiction part of the argument. They unanimously refused to entertain it. And there are two sets of reasons as to that. And the majority relied solely on the question of stare decisis, and you see that at page 32. And you see the question is divided into the two that I've referred to. Just under D, there's little Roman numeral 1 and little Roman numeral 2. So the first question is the question of the power to authorise service out, which is the territorial question, and the second is the power. And then you'll see at paragraph 2, they say to accept the first of those propositions would require the board to depart not only from the decision of the House of Lords in Susquehanna, to which Lord Nichols was referring in Mercedes-Benz, but also from the board's decision from which Lord Nichols dissented in the Mercedes-Benz case itself. In the board's view, those decisions should not now be disturbed. If we go on to page 42 of the bundle, you'll see he goes through all of the authorities, and you'll see what he says at paragraph 34. What makes Lord Nichols' dissenting judgment of enduring relevance is not his interpretation of the Hong Kong rules of court, which did not prevail, but his illumination of the nature and purpose of a freezing injunction. And so that's the force of convoy and broad idea. Not does this sort of claim fit within the territorial jurisdiction of the courts, wherever they may be. Should it fit within the territorial jurisdiction? None of that is being addressed in the reasoning in convoy and broad idea. What is being addressed there is the power issue. Page 51, if I may. Again, and Lord Legate says, he goes through the merits and demerits of it all, talks, and then he comes on to the injunction against Dr. Cho. He summarises the arguments, and then at page 51, paragraph 67, he says, whatever merit it might have had, if the question was a new one, CCL's argument that this rule encompasses a claim made for a freezing injunction comes far too late in the day. The common law does not operate on a principle of third time lucky. On the contrary, at its core is the doctrine stare decisis, meaning stand by what has been decided. That doctrine remains as essential as ever to securing stability, consistency and predictability in the common law. Now, so Lord Legate really didn't engage in too much detail in an analysis of whether or not a freezing order was an injunction within the meaning of that gateway. But the minority did, and Sir Geoffrey Voss, the Master of the Rolls, went through it in a bit of detail. And you see that at page 84 of the bundle. And it's paragraph 190. So he considers the argument, page 84, paragraph 190. He says, in my opinion, there's no good reason for the board to depart from its previous view of what Lord Nichols described as a short point of interpretation. There are several reasons for this approach. And the first set of reasons, and he goes through his reasons, and we don't need to go through it because it's on a slightly different point. It's on this point about whether an injunction gateway responds. And so, for example, at the top of page, he looks at the scheme of the rules, and at the top of page 86, he says the scheme of the rules shows that the injunction gateway only applies to substantive claims for injunctions. And then he goes on to say, nothing's changed to depart from that rule. So he says that at paragraph 198. And then at paragraph 199, importantly, potentially for our purposes, he says this. Fourthly, the argument that Lord Mustall's reasoning on the service out issue in Mercedes was influenced by the opinion of Lord Diplock on the power issue in the Susquehanna is wrong. In fact, as I've said, Lord Mustall assumed in his reasoning in Mercedes that the Susquehanna had been wrong to decide that a freezing injunction could not be granted to support proceedings in a foreign court. So just on this narrow question of construction, the consistent approach across the whole world, with the possible exception, you tell me, of Australia, is to construe the jurisdiction gateways as permitting enforcement of foreign judgments as only becoming available where there is a judgment to enforce. That's because when the discrete question of construction has been looked at, they've taken that view, and when the issue is not raised, they've reached the conclusion that there is no jurisdiction. So when there would have been jurisdiction if the enforcement gateway responded. So taking Dr. Cho's example, he wouldn't have needed to use the injunction gateway if it had been available to him to use the enforcement gateway. The board idea makes no change to that. And the decision on the power issue, the recognition of the enforcement principle, had no effect on the jurisdiction, the territorial jurisdiction issue. And you see that where the Master of the Rolls says so in terms. And one can see there's more scope for argument there. So say, for example, that Article 32 of the DIFC court law said the court has territorial jurisdiction to grant orders and injunctions. So imagine that it was apt to confer jurisdiction. Then we probably wouldn't be sitting here today because the literal language would include freezing orders. And so those policy arguments and the argument that if we've got the power, then it must be that we have that power in anticipation of a future judgment, cannot answer the question, does the enforcement gateway respond to this sort of claim? We say in part the confusion in the argument from my own friend comes from the term the enforcement principle. Can I just check that we still have Peter Gross, because we've lost his video again.
Thank you.
I'm so sorry.
Here he is.
You did lose me for a brief period. You were on page 51. I don't know what you said about page 51, but whatever it was, it caused my connection to fail.
That was the key point. Can I just run back very briefly and tell you what I said?
I'm so sorry. I'm so sorry.
If it's easier, by all means, it may be easier if you do turn off your camera, because that might reduce the data requirements. I don't know.
Let's see how we go.
I think we may have a more serious problem now.
Yes, he appears to have frozen. Oh dear. Justice Gross, can you hear us? One of the court officers try to communicate with Justice Gross.
Yes, Your Honor, I'll just try to fix this problem.
Thank you. Sorry, Mr. Montague-Smith, we're
Not at all.
interrupting your flow, but you can have a brief respite. Actually, how are we going? I was just thinking what might be a bad idea is if we took a break just for 5 minutes or so, because we've been going for a fair while. There we are on again, I think.
Would you, Your Honour, be kind enough to make that 10?
Yeah, just a moment. I just want to see what happens with Justice Gross. Look, we still just got the initial. So how about we take a 10-minute break? So it's 7:10 my time, which will be 7:20 when we come back. Okay, all right.
Certainly. Thank you.
Thank you.
I may, Mr. Montague-Smith, I'm sorry about that.
Not
I
at all.
lost you when you got
Yes.
to page 51.
Yes.
What I might do, if no one minds, is go dark in the sense of closing down the camera in the hope that assists.
Okay, that's fine. I think that was
But,
Mr. Montague-Smith's suggestion, in fact.
Right.
The
Okay.
only problem we might have is knowing whether Sir Peter is still with us or not.
I see the force of that.
Maybe you should.
Okay.
Maybe you should just cough at intermittent intervals to reassure us.
More questions, perhaps.
Okay, let me leave the camera on. If it starts flickering again, I'll switch the camera off and cough intermittently.
Okay, right. Yes, Mr. Montague-Smith. Oh, wait a minute. We need.
I think we may have
Mrs.
lost. Yeah. Is it Sullivan? Oh, there she is.
Yeah.
I'm sorry about all that.
Not at all. Not at all. All right. Well, look,
Right, Mr. Montague-Smith.
I won't labour the bits that you missed, Sir Peter, but I will just make the point briefly that we got to page, was it 51?
Yes.
And I was just making the point that the minority, the majority in Convoy refused to revisit the question of statutory construction and territorial jurisdiction. The minority went a bit further, and at page 84, you can see that the Master of the Rolls went into a more detailed analysis of the rule and said, paragraph 190, in my opinion, there's no good reason for the board to depart from its previous view of what Lord Nichols described as a short point of interpretation. And so there's a series of reasons for why. And at the top of page 86, he reached the conclusion that the scheme of the rules showed that that particular injunction gateway only applied to substantive claims, and then nothing had changed. You'll see paragraph 198, nothing had changed to justify a change in the decision. And paragraph 199, he says this, and this is potentially significant. The argument that Lord Mustall's reasoning on the service out issue in Mercedes was influenced by the opinion of Lord Diplock on the power issue in the Susquehanna is wrong. In fact, as I've said, Lord Mustall assumed in his reasoning in Mercedes that the Susquehanna had been wrong to decide that a freezing injunction could not be granted in support of proceedings in a foreign court. So actually, if one just takes narrowly Dr. Cho's position, the answer was there was power if there was jurisdiction, but there was no jurisdiction. So the power cannot by itself create or justify creating jurisdiction by what I would say is a departure from the literal terms, the literal words of the rules with which one is faced. And similarly, in my submission at least, on the narrower question of construction with which you are faced, which is what is the meaning of a claim to enforce a foreign judgment, we would say that there is a consistent approach across all of these different courts, which appears to construe that as requiring a judgment, an actual existing judgment before the jurisdiction is enlivened. And we would say that that logically can't change by analysing a claim for a freezing order as somehow ancillary to a claim which has not yet come. Because if the claim has not yet come, then the jurisdiction has not yet come. And indeed, we would say a claim for the freezing order is not ancillary to or part of the substantive claim or indeed the same sort of thing as the substantive claim to enforce the foreign judgment if and when it comes. In part, we say that the confusion of that may have come from the use of the term the enforcement principle, because that doesn't mean that a freezing injunction is a form of enforcement. It's actually quite the opposite. And we have to go back a little in the Privy Council's decision just to see what that is, because when one understands what a freezing injunction is, one can see actually, we say, that is inconsistent with a claim for a freezing injunction fitting within the terms of this statute. So at page 56, paragraph 83 gives the headline, and it says 3 lines down, at this stage of the law's development, it is possible to go further and to recognise that a freezing injunction is not, on a true analysis, ancillary to a cause of action in the sense of a claim for substantive relief at all. Now, the appellant, I effectively recited that and said a freezing order is not ancillary to a cause of action, and my learned friend has taken issue with that in her skeleton argument at paragraph 57. But we say that really emphasises that the appellant is misunderstanding the force of broad idea in this case, because Lord Leggatt goes on to explain what's meant by this, and I can romp through the reasoning a little bit. But if we look paragraph 84, starting 4 lines down, he refers to prior rationalisation, Susquehanna rationalisation. The rationalisations then advanced, which sought to justify the grant of Moravian injunctions on the basis of either an interest in the assets frozen or a right to the sum claimed in the action. In Channel Tunnel, the question didn't arise, as the interlocutory injunction sought in that case was what might be termed an orthodox interlocutory injunction, granting on a temporal and provisional basis the substantive relief claimed by the applicant, albeit that the claim for final relief was being pursued before another tribunal. It's been clear, at least since Mercedes-Benz, that a freezing injunction is different in character. As Lord Muscle observed in the judgment of the board in Mercedes-Benz, the Moravian injunction does not enforce anything, but merely prepares the ground for a possible execution by different means in the future. And then the last 2 lines of the page, in other words, as Lord Nichols spelt out more fully in his dissenting judgment, the essential purpose of a freezing injunction is to facilitate the enforcement of a judgment or order for the payment of for the payment of a sum of money by preventing assets against which such a judgment could potentially be enforced from being dealt with in such a way that insufficient assets are available to meet the judgment. So the consequence of this is that the claim that you have before you today, claim for an injunction in support of foreign proceedings, is different in character from a claim to enforce a judgment. That's the orthodox understanding. That's the thrust of Lord Nichols' dissent. And if we apply that here, we say that's diametrically opposed to what the appellant's case is, because you've got if it's different from the substantive claim, what's the substantive claim in this court? It's got to be, to fit within the gateway, a claim for enforcement of a judgment. And in the DIFC, that's understood on the common law approach to mean an action on the debt created by a judgment. And that's a fresh cause of action in the DIFC court. We know that from DNB Bank. And the law of the DIFC, it treats judgments in that way. And so, in effect, it's another kind of debt that's actionable. But that is not the nature of a freezing order. So what is happening is Article 24 is permitting the court, giving the court authority to adjudicate on claims for the enforcement of a debt, and it requires that the judgment exist, because otherwise there's no debt. And so that is not what a claim for a freezing order is. So if that is right, it cannot come within Article 24. It would, in other words, put it this way, the source of the freezing order power is not the substantive claim. The source of the power to grant a freezing order is the particular provisions in England of the Senior Courts Act, which permit it to grant an injunction. And so if the source of the power to grant a freezing order also brings with it territorial jurisdiction, well, then the arguments have to be focused on Article 22, Article 32 as somehow creating freestanding jurisdiction. On page 58, paragraph 89, Lord Legate says, although it's unnecessary to make the enforcement principle dependent on identification of a legal or equitable right, there's no harm in expressing the interest of the applicant which a freezing injunction seeks to protect in these terms, provided it's understood to be different and different in character from the right in which a cause of action for substantive relief is based. So that supports my submission that a claim for a freezing order of this sort just isn't a claim to enforce a foreign judgment. It has the use to help you do that in future, but that's not what it is. That's the orthodox consideration. And Lord Legate actually goes further, and he says at paragraph 91, the point that analytically there is no connection between a freezing order and a cause of action for substantive relief. That's why there didn't need to be a cause of action to enliven the power at that stage. And the minority agreed with that outcome, although they considered that they didn't need to go back into the power issue. It wasn't right to revisit the power issue, given that it had been decided previously. But the effect of convoying broad idea and the effect of Lord Nichols' dissenting judgment in Mercedes-Benz does not give any support. And the fact that it's labelled the enforcement principle gets confused, because one then thinks, well, what we're talking about here is an exercise in enforcement, but it's not that at all. We're not in enforcement territory, and therefore we're not within the enforcement provisions, the powers which gives the court, the legislation which gives the court territorial jurisdiction to enforce cannot also be the source of the territorial jurisdiction to grant a freezing order. Those powers come from different places. One brings territorial jurisdiction, the other does not. All right, so that's the fourth point, which is that broad idea doesn't support my learned friend and actually undermines her position. The fifth point is what has been the reaction to this part of these judgments, because it's been suggested that adopting what has been characterized as a Skinner type approach puts this court outside the international mainstream. What's been the reaction? My learned friend's submissions suggest that the result that's equivalent to this, that there's no territorial jurisdiction in these sorts of cases, unless there's some other nexus, some other gateway satisfied, puts us outside the international mainstream. And one might be forgiven for thinking that there's been, therefore, a lot of criticism of the equivalent decisions that come before. We say that is absolutely wrong. Your Lordship, Sir Peter Gross, asked for some articles from the Law Quarterly Review, and we've located one. You'll find the relevance passage of it. It starts at page 1087, the bundle, and you'll see it's a 2022 commentary on broad idea. And most of the focus of this, of course, is on the power issue, because that is the issue that Nichols is talking about, Lord Nichols. But actually, it does look at the territorial jurisdiction issue as well. So if we go to page 1089, you can see in the middle of the page the central paragraph, 4 lines up from the bottom. Lord Nichols then proceeded to the first question, territorial jurisdiction, and found that the rules of court could be interpreted to encompass freestanding injunctions within the provision for service of process out of the jurisdiction. Lord Nichols' judgment was not so convincing on this issue as on the question of subject matter jurisdiction or power. So that's recent commentary on Lord Nichols' dissent on the question of territorial jurisdiction. It was not so convincing. And then the author goes on to say, talk about broad idea. I won't read out the passage, but explains what happened there. But the final sentence is the conclusion that's drawn on this. This is the international commentary on these sorts of conclusions. There cannot really be too much quarrel with this view. So the appeal against the lower court's decision in favour of the second respondent, Dr. Cho, was quite properly dismissed. So there's we would say, so there's no mention, by the way, in this article of the argument that was also raised in Mercedes-Benz, which Lord Nichols also agreed with, which was that the enforcement gateway did not respond to the claim as it was put for an injunction. And we would say that the reason that that was not brought up is because it's too obvious to mention. It's not a controversial conclusion in Mercedes-Benz that the enforcement gateway does not respond to these sorts of claims. So my learned friend refers to an article by Lord Collins, which followed quite shortly after Mercedes-Benz. And of course, Lord Collins is always a source to be respected in questions of this sort. However, that article was not directed at the decision on the enforcement gateway. It was directed at the power issue first and foremost, but then also at the jurisdiction, sorry, the injunction gateway. And also, by the way, that article was considered in Broad Idea. You'll see it on page 42 of the bundle at B. And it was not enough to suggest that the court should strain even so far as to conclude that an injunction in the injunction gateway included reference to a freezing injunction. So I've not detected any other adverse comment on the decision on jurisdiction. There obviously has been plenty of adverse comment on the decision on power in the original Susquehanna judgment, and that has been turned around. But nobody has suggested, well, there's certainly no consensus of suggestion that it must be the case that where the court has power to do these things, it must always have jurisdiction to do these things, or indeed that it ought to have jurisdiction to do these things in a case like this. So that's the fifth point. The sixth point, which we've debated whether it fits here or perhaps later in the stare decisis part of this, is that the court, we say, should not legislate. It's a slightly different approach to a different question about whether it should revisit its recent decisions. But there are lots of arguments that come from policy in relation to this. Those are about what the rules of jurisdiction in this court should be. And we say those sorts of arguments cannot overcome the words of the rule itself. And your honours know that this court has held the line against judicial lawmaking on more than one occasion in the past, where policy has been, quite firmly in favour of some other conclusion. The two obvious cases we refer to very briefly, I'll remind you of the passages, if I may. The first is Lis and El Seco, which you will find at the passage at page 270 of the bundle. And it's paragraph 77. And endorsing an observation from Lord Diplock, we can just look at the passage 3 lines in. More fundamentally, as Lord Diplock observed, 2 lines in, I apologise, underlined, where the meaning of the statutory words is plain and unambiguous, it's not for the judges to invent fancied ambiguities as an excuse for failing to give effect to its plain meaning, because they themselves consider that the consequences of doing so would be inexpedient or even unjust or immoral. And then more recently, the case of TIG, or the industrial group, which we find page 415 of the bundle, paragraph 105, where your lordship, Sir Peter Gross, I think, may have been a judgment from the whole of the court, I apologise, but the Court of Appeal says, paragraph 105, it does not, however, follow that the DIFC court's judges are free to incorporate into DIFC law any common law developments from any common law jurisdictions, simply because there's been such a development elsewhere and because the outcome might prove attractive to the judges sitting on the individual case.
That was a pretty extreme case, if I may.
It was extreme for a number of reasons,
yes.
And it excluded from the law of the DIFC an entire tort which existed and has existed for a very long time in the common law systems. And what it does is it says you can't say it would be good to have that. There are very strong policy reasons in favour of having that, and therefore we have it. And your honours have seen the consultation that went round recently about how to, quotes, fix the problem created by TIG.
Yes.
And my view is
there are views, Mr. Montague-Smith, about the consultation and whether it understood the industrial group correctly.
Well, I would take exactly.
I think, in fact, Mr. Montague-Smith, in Lal's group, which came out recently, the court said something about that and the approach to the common law. But coming back to your point on statutory construction, I think it's uncontroversial that I prefer the term really constructional choices rather than ambiguity, because the question is what constructional choices are open, and it's important, and the High Court itself has said this, that in Australia, that you don't find a desirable policy of your own and then make a constructional choice to fit it. You look to the purpose and policy of the statute itself, so far as it can be divined.
Yeah, absolutely. One looks for the policy, but when one gets into the question of territorial jurisdiction, it's extremely tempting for the court to start from the proposition, I'd like to make this order. If I had jurisdiction, I would make this order. And to jump from there to, well, the policy must be to allow me to do that, because the law says that if I have jurisdiction, I should be making this order. And that is the illegitimate leap. No doubt there are policy arguments in favour of the court having territorial jurisdiction in a case like this and other cases of this sort. But I would suggest that there is no international consensus to that consequence. First, we've looked at the cases where that's not been the case in a whole range of jurisdictions. But secondly, I've referred to, I'm afraid not from the Law Quarterly Review, but from the Comparative Law Quarterly, which addresses the question of whether or not the English position actually goes too far and argues quite persuasively that it does so. And that comes at the question from a more civil law, I would suggest, perspective rather than from the English perspective. And I'll just show you a couple of passages of it in a moment. But ultimately, the point that's being made there is that, firstly, English law, DIFC law, you know, the Australian law, dare I say it, is not the final word on what it means to exercise comity and what significance one takes from rules of territorial jurisdiction. It's not just about the relationship between the parties to the claim. And so what Mr. Siranovich urges is what he refers to as a multilateral or horizontal concern about jurisdictional rules, about respecting the boundaries between states and their authority to make decisions. And what he suggests is that the English approach fails to take on board that interstate, that wider dimension of international law. And what it does is it confers on the English courts the power to make a freezing order in any case where the foreign court has jurisdiction and there's a claim over that. And he says it pushes everything onto the discretionary stage. And so what he says is, and that's part of the argument against me. Well, what's the problem in having jurisdiction? We still have a discretion. So we'll take into account the fact that this case isn't connected to the DIFC when we decide whether to exercise that discretion. So it's one answer that's put against me. And so Mr. Siranovich, for example, says, well, that's just not the solution. If we go to page 1100, I won't labour through this, and you don't have to reach a conclusion on this, but it is a respectable counterview to all of this. He talks about the sorts of limitations imposed by the English courts on the exercise of their jurisdiction in a case like this. And so at page 1100, second paragraph down, he refers to the cautious approach of Mr. Justice Walker and says it should be applauded, particularly the careful separation of jurisdictional enforcement issues. The outcome in Mobile is undoubtedly correct. Nevertheless, the reasoning is still inconsistent with a multilateral approach to the existence of jurisdiction. And the most significant question, whether the English rules on freezing injunctions were applicable at all, should not be left to the discretionary stage. And then a few pages down, 1112, it's an interesting article. And again, we don't have to come to conclusions on all of these rather complicated questions. But in the middle of 1112, for example, he says, given the lack of importance attached to the question of the existence of jurisdiction and the fact that the only device for controlling the scope of relief is the test of expediency at the discretionary stage, The current position demonstrates a unilateral approach to the existence of jurisdiction to grant a worldwide freezing order in support of foreign proceedings. A unilateral approach tends to give disproportionate weight to the forum's policies and ignores the internationalist and systemic goals of private international law and its public international roots. In other words, what he's saying here is, by the time you get to discretion, the court's already abrogated to itself the right to choose the rules by which that discretion is exercised. Now, we can debate the merits, demerits of that view, but it is not correct to say that everyone thinks an English-style Civil Jurisdiction and Judgments Act gateway is the right way to go. There's a range of views about how we approach this, and it's correct that in some, sorry.
He sounds a bit like the European Court in Luxembourg.
Well, if he does, then that indicates that the European Court in Luxembourg, at least. I mean, one can have different, varying degrees of respect for it. But you know, I think one has to make sure that clear views, if I can put it like that, about who is right and wrong, don't become my way is the right way and there's no other way of looking at this. And there are a range of views, because in Singapore, for example, you know, gateways have been effectively eviscerated, because what's happened in Singapore is that what we have in England as gateways to jurisdiction are just examples of the sort of case in which jurisdiction will be exercised. So it all comes down to foreign non-convenience, and the gateways are only illustrative. And that is something that was considered by the Civil Procedure Rules Committee in England, but there just wasn't the bandwidth in the subcommittee that was put together to actually decide it. And it would have had to go to a much more considered view. And the Master of the Rolls in Convoy also agreed that this is not for the courts. This is for legislation and CPRC. And by the way, he's the head of the CPRC, so he would know. But Mr. Saranovich certainly suggests that the effect of the legislation in England, just to give jurisdiction and leave it to discretion, is a step too far in eviscerating jurisdictional boundaries, because the effect of doing it is to superimpose the DIFC approach onto a case which has nothing to do with the DIFC. That's the logical consequence of it. And the point only arises because this remedy is not available in these circumstances in the court where the order has been, the proceedings are going ahead, or indeed in the location of the assets, which is outside the DIFC too. So my learned friend said, well, the reason we're here is because the Dubai courts cannot give us this form of relief. I would suggest that's inaccurate. It's not correct to say they cannot give this form of relief. Attachment orders, which have the similar effect of freezing orders, in fact, they have a stronger effect than freezing orders, are available in the Dubai courts. They're just not available in these circumstances because they have different rules about when they give this sort of relief. So saying as a matter of policy, well, we think the DIFC rules are better than the rules, for example, in the Dubai courts, is not a good reason to say, well, we're going to have jurisdiction, we should take jurisdiction in a very broad way.
Anyway, I think the point is clear enough that constructional choices are not driven by what we think is a desirable policy.
Thank you. And we saw that in the Susquehanna. We saw it in VDB Capital with Sir John Chadwick, and we say that it's a matter for the legislator to change it. My learned friend, I won't take you to them either, but my learned friend refers to comments by Lady Hale and Lord Hodge in articles. I just remind you that those are about a common law system which acknowledges judge-made law. It's not a statutory system, but anyway, they acknowledge the limits of the judge-making abilities. And so we say, ultimately, the language, the literal language, we say does not capture this claim. That is consistent with, at least we would say, the majority, if not all, possibly, of the international authority. It is also consistent with broad idea, and even if one does take into account those policy considerations, those were not sufficient to broaden out the view of jurisdiction in England to take the simple step. What Lord Collins describes in his article as the obvious step of just concluding that a freezing injunction is an injunction within the injunction gateway. All the more straining is required, we would suggest, to conclude that either a non-existent future judgment, which may or may not have actually come in, is a judgment, or indeed that the claim that you're faced today is the enforcement of a judgment. So those are the primary points that I wanted to make about it, about whether or not the court in Sandra Holding was right. What if you would disagree with me? What if you think that you would make a different decision? We would say you should not revisit this even then. We explain, both parties explain in a bit of detail why stare decisis is an important principle. I don't see any argument against that. That there are situations in which
I suspect it's not controversial that the mere fact of us taking a different view on Sandra Holdings is a sufficient reason for overturning. There are other factors in play, and I referred to some of those in the John case. I'm sorry you didn't have a reference to that previously from us.
Not at all, and you may have to remind me of the checklist to ensure that I've covered them off. I did note it down somewhere, but I've got no idea where, quite frankly. I think
they're pretty straightforward. Firstly, whether the earlier decision rested on a principle carefully worked out in a significant succession of cases, so it's part of the stream, if you like. Secondly, whether there was a difference between the judges. That's not this case. There was a unanimous decision. Thirdly, whether the earlier decision had achieved a useful result or caused considerable inconvenience. Well, you can argue about that. There's no empirical evidence in. And fourthly, whether the earlier decision had been independently acted upon in a way which militated against reconsideration. That doesn't seem to be this case. It hasn't been run long enough.
Sure. No, and I understand that. I mean, all of those, though, are reasons described not to go back and interfere. And so they come at it from the conclusion that unless there is a reason not to interfere, one interferes. If that is the sort of thrust of that approach, then that's an unusual approach to prior superior court decision making.
And there were reasons for interfering. I'm sorry, I better come back to it and make sure.
So carefully worked out, for example. Let me just approach them one by one. That might be the easiest way to do it.
Yeah.
I was going to show you some authority which suggests other things as well, but just carefully worked out. The points I'd make in relation to that are Ahmedova has been stood for what, a decade now. I may have that wrong, and that is clear. We would say. As saying that prior to the judgment against the particular defendant, you can't enliven the jurisdiction of this court. We do say that's inconsistent. And secondly, I mean, you've heard quite a lot of disparaging comment about the Sandra Holding decision, but what cannot be denied is that they went through each of the prospective gateways, took a view on construction, and took into account that broad idea had been decided. And it was suggested in the course of argument, perhaps Jones and Jones, for example, might be a reason why we can go back and have another look at this. And I would suggest not, because Jones and Jones obviously was decided prior to, and simply adopts the reasoning in Latif, which we say is where everything goes wrong, because Latif is where it goes wrong, because Latif says freezing orders ancillary to the enforcement, to the cause of action, which is wrong. So has it been carefully worked out? I mean, we would say
just to make clear how it's stated in John, yes. They're relevant considerations. So it's a relevant consideration whether the earlier decision rested upon a principle carefully worked out in a significant succession of cases. Now, obviously enough, that would be a consideration against overruling. Yes. Secondly, whether there was a difference. Now, if they were unanimous, that would be against overruling. If there was a difference and powerful dissents and so forth, maybe. Whether the earlier decision had achieved a useful result or caused considerable inconvenience. Well, it's obvious which way those considerations would fall. and whether it had been independently acted upon in a way, in other words, that people have relied upon it. And
Yes.
There's a long history of reliance upon it. That would militate against reopening.
Yes. Yes. No, I think my comment was that if one provides a checklist like that, one rather it could indicate that if one puts aside those factors, the position is otherwise neutral. Whereas my position is one starts from a very strong a very strong prejudice in favour of following the prior decision, unless there are exceptional reasons to move away from it. That's all.
But I suspect, again, there's no controversy that stare decisis is pretty important, and predictability and continuity in the law is important. So you probably don't have to convince us of that.
Sure. No, and so what I was going to try to convince you, though, is that there is particular force in relation to that in respect of decisions which construe statutes. So when it's about statutory construction, the stare decisis principle has been applied with particular force, and that's a position that's been adopted, at least in England and the States. So I was going to show you very shortly some passages from that. I don't think it'll take me more than 10 minutes.
You're talking about the US Supreme Court in Kimball, I think it is?
Yes, correct. But I'm also talking about the English Supreme Court in Hudson.
Well, are the underlying principles are not in dispute, are they? It's really a question of application in this particular case.
Correct. But my point was simply, well, if it's accepted that there is a particularly heightened concern about stare decisis when we're dealing with statutory construction, then yes, absolutely, then I don't need to show you that. But if that's not accepted, then I do need to show you that.
Well, a judge once remarked to me when I tried to get a response from him on one of my propositions, you can't treat a judge like a cake and prick him with a knitting needle to see if he's done. But
yeah, well,
Justice Lemiere will remember Sir Francis Burt. Actually, it wasn't me who said that, was the other side. But in the context of the case I referred you to, there is a distinction made in Australia between constitutional cases where the legislature can't fix it. So there is a higher threshold for intervening in overturning a statutory interpretation. Whether you call it heightened or particularly high, I suppose they're sort of qualitative terms.
Yes, but certainly in Hudson, 4 out of the 5 judges weren't concerned about constitutionality or whether or not what they were interpreting. The position was, I mean, I can summarize it like this.
Mr. Montague-Smith, you want to take us to Hudson? I have a feeling you're going to. Why didn't you go straight there?
Well, why don't you can take most of it from me, but if we just go to page 514.
I'm happy to take it from Mr. Montague-Smith.
Fine. The test that Lord Pearson gives in 514 is whether or not the competing constructions are, quotes, tenable. That's the distinction that he draws. He explains, look, I'll give you the reference. It's page 514. I can give you all the references if you like. Lord Wilberforce was slightly different, but there were Lord Reid, Lord Morris, Lord Pearson and Lord Simon all said roughly the same thing. But Lord Pearson takes the position that statutory construction, one can always take a different view. And the reason why is because some people prefer to emphasize the literal words of the statute. Other people prefer to emphasize the contextual matters, the policy matters and so forth. And so what that means is that one has to be particularly cautious about revisiting those, and it is not appropriate where the prior court that you're being asked to overturn has taken a view which is, quotes, tenable. So that is what he says. So what I say, now you may decide that Sandra holding it is not tenable to decide that a claim for a freezing injunction in support of foreign proceedings is not within Article 24 of the DIFC court law. But I would suggest that that would be quite an extreme conclusion given the literal language of those provisions. It is at least tenable, we would suggest.
But sorry, Hudson dealt with a very wide-ranging statute, didn't it? Dealing with disability benefits or something like that?
Yes, it did.
So it's a bit different.
I agree. I agree.
It's I mean, the context, I'm not saying your point is wrong, but the context is a very different one from looking at the position on freezing orders in support of prospective judgments. I mean, these social policy issues
I hear your point. Sorry, I'm interrupting. I thought you finished.
No, you're not at all.
I heard your question to Ms. O'Sullivan about the question of legislative competence, comparative legislative competence, and I would accept
institutional competence.
Sorry, institutional competence, I would accept that there is that distinction. I would not accept that this is somehow, therefore, this particular discrete issue that we're talking about, the extent of territorial jurisdiction, falls into the sort of the category of decisions which this court can interfere with in a more liberal way, if I can put it like that. This is a slightly different question, though, which is that once the issue has been decided, when is it appropriate for this court to go back on that decision? Now, I accept Hudson is about a different statute in a different context. I do accept that entirely. But the reason I wanted to take you to it is because those expressions of principle about when it is appropriate to go back are not confined to that context. And
thank you.
I mean, it does sound like that is in dispute, and it is worth just me making that good briefly without labouring it. But if we go to 484, for example, this is Lord Reed at D. I would venture the opinion that the typical case for reconsidering an old decision is where some broad issue is involved, and it should only be in rare cases that we should reconsider questions of construction of statutes or other documents. Very many cases it cannot be said positively that one construction is right and the other wrong. Construction so often depends on weighing one consideration against the other. So, and then goes on to talk about, Lord Reed talks about, if more attention is paid to the meticulous examination of the language used, the result may be different from that reached by paying more attention to the apparent object of the statute, so as to adopt the meaning of the words under consideration which best accord it. Now, in that case, there were other reasons specific to that statute for not going back and reconsidering the decision. Of course there were, but this was a key and important reason that was relied on for not chopping and changing. And you get comments by Lord Morris, for example, on page 491. I mean, broadly the same. Page 973 of the decision at C, just that paragraph. It was essentially a decision which involved questions of construction of the statutory provisions, if any proposals for change are now suggested it should be for Parliament to consider and decide whether they're necessary. I've shown you, I think, what Lord Pearson said, and Lord Simon said something very similar. And the US Supreme Court takes a similar approach in the Kimball case, and I've referred to that. Effectively, they say the ball is in the court of the legislator. Once we've told you what that means, the solution, if you don't like it, is not to come back and change the interpretation. The solution is to change the legislation. And in Kimball as well, and this might, I mean, I'm hesitant to try your patience, but it does seem to me to be potentially important to get these principles right, because they've not been declared previously, at least expressly in the DIFC courts, and so it does come into sharp relief in this case, and probably the court will want to look at how other courts around the world have decided it. Page 991.
Just a minute, we seem to have lost Justice French.
Oh.
I'd assumed he was still there, but no, without a camera.
Yes, for some reason, my camera went off. Maybe I touched the mouse. Okay.
No problem. Sorry, it's so 983, for example, is where 983, just in the middle of the page. I'm only showing you very short passages here. This is the Supreme Court. Stare decisis carries enhanced force where a decision like Brulot interprets a statute. Unlike in a constitutional case, critics of our ruling can take their objections across the street, and Congress can correct any mistakes it sees. And Kimball also talks about arguments from policy, which is on page 991.
The comparison that's being drawn there is between statutes and constitutional cases rather than common law. And I've seen it suggested that the courts are more flexible in relation to departing from decisions on statutory interpretation than on changing the common law. Sorry, the other way around. They're more cautious in relation to changes in the common law than in statutory interpretation.
No, that's the opposite of the position. That's the opposite of the position that I've been showing you in Hudson. So what Hudson tells us is that development of the common law in a common law system is judge-led. And therefore it's more likely to be the case that changes in political, social background, matters of that sort, will be relevant to it. But pronunciations on statutes are not in that category. And therefore, once we've decided it, unless something's gone really wrong, we won't go back and do it again. So I mean, if the suggestion is that statutory interpretation chops and changes more than the common law, then that is definitely, there is a difference between us about what the principles are here, because the authorities say the opposite, actually.
Yes, I'm referring, I haven't read in great detail, but I've come across an article in Australia in which the authors say to this effect, that authorities can be found endorsing both a flexible and a more constrained approach to overruling constitutional cases. When asked to overrule itself in the interpretation of a statute, the court has not been averse to a degree of flexibility. However, when it comes to the common law, while the court has been prepared to overrule in appropriate cases, the attitude of the court to overruling has been more consistently cautious than in matters of constitutional or statutory interpretation.
Right. Well,
obviously a different view.
The view from Australia is different, is very different from the view from the UK and to the view from the US, I would suggest. So if that is the view, I mean, I don't know. Your Honour's reading it out to me. It's not something that my learned friend has argued. No. We've approached this on the basis that the DIFC court ought to approach stare decisis broadly as the English courts approach it. And so we have all referred to, for example, you've had read out to you the practice direction from the UK Supreme Court. We've seen Convoy and Broad Idea, the way that they approach stare decisis. Those are the principles that have been urged on you by the parties. Now, doesn't mean you're bound by what we say about it, but if your view is that those are not the principles, then we ought to have probably the opportunity to consider all of that and tell you what we say about that. But you know, the conclusion of that, in my submission, if that is right, is that Australia is outside. And I appreciate I'm saying this to two Australian judges, but Australia is not adopting the mainstream, and that's not unusual, if I can say it like this. So one situation where that has been found in this court, actually, in the Court of Appeal, was the Protivity case, where the argument on the other side against me was that the DIFC court should adopt the Australian approach to foreign non-convenience. And the other alternatives were the English approach and the US approach. And the Court of Appeal went through those different approaches and decided it preferred the English approach. Now, you may say that ultimately says more about the judges in that case and the composition of the bench than anything else. But ultimately, that's the path we've been going down. That was 2017. That's the path we've been going down in this court. So in my submission, the right approach is to follow on from those sorts of authorities.
I don't think it's right to say, I mean, the English approach, English common law is, English authorities are obviously very influential and persuasive, and we said that recently in Lal's group, but we're an international court, And so we draw upon all sources of law, and a lot of what you've been saying, of course, falls within the framework of a comparative law approach, which is quite helpful, especially when you're talking about transnational commercial law and the question of what works across boundaries, which is distinct really from comity. But I don't. And I think there's something of that reflected in the advisory opinion that the Court of Appeal issued quite a few years ago now, when the question arose about whether the common law of England was the sole source of interpretation of trusts and so forth. And we said, yeah, very important, but not the only one. So I think to identify one or other jurisdiction, recognising, as we do, the importance of the English jurisdiction as mainstream is maybe putting it a bit high.
Well, I'm not sure I'd put it that high. And I'm certainly not being dismissive of the Australian.
You use the word mainstream.
Well, the reason I use the word mainstream, if I can put it like this, is that certainly the weight of jurisdictions that follow the Privy Council in particular gives rise to if the Privy Council says this is the right approach, then that is an approach which affects a very large part of the offshore world, if I can put it like that. So that's the only reason. That's the only sense in which I said mainstream, and I didn't mean. What I'm not doing is suggesting that it's inappropriate to look to Australian authority. But if the answer is that the Privy Council, the US, the UK, and all the jurisdictions that the parties have been looking at take one approach, and Australia does it differently, then yes, of course, it's open to you to do it differently.
Well, the Privy Council is really the UK. It's the same judges.
But it affects the approach that's taken across the world in offshore centres.
Where are we talking about? Caribbean republics?
Well, I mean, with respect, that's also somewhat dismissive as well. I mean, those Caribbean republics are the model.
Cayman Islands.
Yeah, but they're the model for the DIFC, aren't they? Ultimately, because what was the purpose of the DIFC was to establish a financial free zone, which does the sorts of things that people do in those jurisdictions governed by those laws. Now, we can't read too much into all of that, but ultimately, if the answer is, if one looks around all of the international financial free zones, Jersey, Guernsey, all those sorts of places, and find that, broadly speaking, they take a similar approach, how much weight do we give to the fact, if it be established, because I'm not looking at it, that Australia does it slightly differently?
Yeah, as a neutral in this particular debate, I've slightly forgotten what we're arguing about.
Stare decisis, and the issue.
I think the point was this, wasn't it, Mr. Montague-Smith? You were putting forward the proposition that the court should be more cautious in departing from a previous ruling in relation to the international interpretation of a statute than, I take the alternative, departing from a decision about a common law rule or principle.
Correct.
I think that's it, wasn't it?
That was it. Yeah. That's the thrust of the debate.
But value out of this now, so we should move on.
We roamed rather widely, and that is no doubt my fault.
Not yours at all.
No. Well, it's interesting in any event. So there we are. But I mean, even if that's not right, what I think must be right. I mean, the way that it's put in the Geelong case, for example, by the Supreme Court, is they say the fact that a decision is plainly wrong is not enough. It's necessary but not sufficient. So you have to show that something has actually gone wrong in arriving at that decision, not just that you disagree. And we would say, the Court of Appeal in Sandra Holding had before it all that it needed to have. I mean, the alternative, and I know you accept the principle, but just to bring out the consequences if you allow that principle to be infringed, the consequence could be today that 2 individual judges on this panel could overrule what we say is the decision of 6 judges, if one takes into account Akhmedova, going in the past. And it may not be that, it may be 3 judges, but can that also be right? And then what happens when the issue comes up again in the first instance decision. Do we just come back to you and have another go? So it is important. I hadn't intended to suggest that Australia doesn't apply sufficient weight.
I think that Justice Lemiere and I have sufficiently thick skins not to be worried about that.
Clearly came across that way, given that the response is that we're not offended, not that you didn't do it. So that wasn't what was intended. Peter Gross is staying neutral, but I think has judged the proceedings. So either way, I think that's pretty much it. That's all I was going to say.
One thing that does arise out of this is a procedural thing, and I don't think it's covered by the legislation. We had a brief discussion about that when this issue arises again, and the practice in Australia, for example, in the federal court, would be to constitute a bench of 5 if you're looking at reversing, or if there's an argument about reversing an earlier decision. Because otherwise it's 3-3 and so forth. But I'm not sure that we have that facility under the existing legislation, and certainly wasn't.
I don't think so.
Possible.
I think I saw a court of appeal is 3 judges, isn't it?
Yeah.
I think.
Anyway, we didn't explore that now, but it's something perhaps for the future if this sort of thing ever happens again.
Yes, I don't know the answer to that question off the top of my head, I'm afraid, but I hear what you say. What you say. Sorry, I should just make sure that I've covered off the four categories that you raise, Your Honour. And so the first was, is it carefully worked out? We say that surely the application of that can't mean that if it's a simple question, then it's more easily reversible, if I can put it like that. So it's a short question. We say that a series of cases. There's been a principle standing since Akhmedova, and that's significant and adds some weight under that category. Was there a difference between the judges? No, so that's in favour of keeping it. We say, has it achieved a useful or convenient outcome? Well, I mean that obviously both parties would take a different view on that. We say that's neutral. Has it been acted upon and relied upon? I don't say that there's any particular suggestion that it has, but for example, the points that one takes in these sorts of cases does turn on what has happened in the past. And if there has been an established principle for a long time, then one can expect people to act on it. But we say that it shouldn't turn just those 4 categories, that there should be an elevated standard in any event.
Oh, they're not exhaustive in any event, yeah.
Do your honours wish me to address the paragraph 7 grounds, obiter and paragraph 99? We've set it out in quite some detail, and it's a fair amount of detail in the judgment itself, which I would I can endorse, unless there's anything specific you'd like me to address you on. Sorry, there was just one point actually on that. It was suggested that if jurisdiction had gone the other way in Sandra Holding, it would have made no difference. That is not correct, because the order on contempt turned on that. And so I can show you that very briefly. It's actually in the appeal bundle itself, page 119.
Yeah.
Sorry, it's not. It's at paragraph, where is it? No, sorry, it's not the appeal bundle, is it? Of course, it's Sandra Holding itself, and it's at page 2 of the bundle, with apologies, paragraphs 3 and 4. So paragraph 3, the appellants succeed on their grounds of appeal that the DIFC courts does not have jurisdiction to grant a worldwide freezing order against the appellants. Paragraph 4, the contempt of court order is set aside based on the lack of jurisdiction. So what had happened is that the order had been made, the defendant had been found in contempt and been punished in various different ways. That was all swept aside because the Court of Appeal found there was no jurisdiction. Your Honour, I'm not sure if there are any questions that you'd like me to address that you haven't already covered, then I'm very happy to answer them, but otherwise those are my submissions.
Thanks very much, Mr. Montague-Smith, very helpful. Mr. O'Sullivan.
You wish to hear from me straight away, Your Honour?
Yes, indeed.
Right, fine, okay. let me just engage then. I've got a few points, but I'll try not to labour too long. Just on the point we've been discussing, I would like to refer you to paragraph 16 of John. Now, I don't know whether my learned friend has seen this. I asked for it, my instructing solicitors have retrieved it, and I asked for it to go to his instructing solicitors, but he's been speaking. But it goes to this point, and I'm simply going to read it out. However, this is about the question of whether there's a different approach when you're construing a statute. When an overruling is necessary, in order that the court perform and be seen to perform its constitutional function of interpreting and applying the law enacted by Parliament, that course must be adopted. Precedent is the best evidence of the law as enacted, but it is not the enacted law. When the interpretation of a statute is dubious, it is the function of the court to resolve that doubt and by its decision to declare what the Parliament has enacted. If a subsequent court prefers another construction of the statute, that mere preference is not sufficient to warrant an overruling of the prior decision, see Babianaris and Lutoni fashions. But if the later court is satisfied that the interpretation placed on the statute by the earlier decision was erroneous, in the sense that, as opposed to the undoubted intention of the Parliament as enacted in the statute, it cannot adhere to the earlier error and refuse to apply the law as enacted, unless the Parliament has itself accepted or adopted the earlier error and enacted a further law on the assumption that the earlier decision was correct. And he said, if there are instances where the earlier error is de minimis, and where the earlier decision can be allowed to stand without significant failure to apply the enacted law, this is not one of them. So essentially, he's making a contrast between a case where the court decides it just doesn't have the same view as the previous court. That's not enough. But if it takes the view that the interpretation is opposed to the undoubted intention of the Parliament as enacted in the statute, that's a different matter. Its duty is to apply the statute and not be bound by the previous decision. And continuing on this question of the threshold, I mean, if my learned friend is suggesting to you that the test for departing from a previous decision is simply, it should be that it's not tenable, that in my submission is putting it far too high. What we see, the Privy Council said there has to be a compelling reason. And as we've seen, they did think that the majority thought there was a compelling reason for overruling the Susquehanna, even though none of them had any appetite for overruling that decision on the question of the interpretation of the court rules. But they overruled its reasoning in respect of the substantive cause of action being required. And the statement from the House of Lords, as we've seen, says that it will depart from its previous decisions where it's right to do so. So that is the test that they pose themselves. But I would embrace all of those. If the test is not tenable, I say Sandra Holding is not tenable. I'd say there is a compelling reason for departing for it and that it's right to do so. And I've made some submissions on the reasons for that. But this is a critically important area of the law. The freezing order is a very important part of the jurisdiction of an international commercial court. And the Dubai courts simply do not have the same powers. I won't go to the brief survey in Jones. It's at page 397 of the bundle, but there Justice Cook comments on the fact, for example, you cannot be certain if you apply for an attachment order onshore that you will be able to apply without notice. You may end up having to notify the defendant and thereby defeating the purpose of the application. So this is a very important part of the law. And one where I say there's clearly been an error of statutory interpretation, and the quickest means of correcting it is for the court to intervene. Now, as to whether the JAL is going to be amended, well, I've been told that by various people since Sandra Holding was passed. I don't know whether my learned friend is party to inside information. I personally have no idea whether or when that's ever going to happen. I mean, that's simply too contingent and unknowable. I mean, I don't even know whether there's a proposal circulating on this particular aspect. But this is something where a very clear answer on the construction of the statute can be provided by this court. So let me return then briefly to the points made by my learned friend on the substance. The first, on the literal interpretation, what Article 24, first of all, okay, first, I don't disagree with his distinction between the jurisdiction and the power. There has to be jurisdiction over the defendant before the power can be exercised. So I don't disagree with him on his approach in that respect. So I'm focusing on the jurisdiction conferred by Article 24(1). Now, he says on a literal construction, it must only apply to the enforcement of existing judgments. I submit that that is simply not the case. It says jurisdiction to ratify. You were taken to a whole load of other cases on enforcement gateways and other jurisdictions where the language is used, says a claim is brought to enforce. That is very different language. My learned friend actually said that we are not in enforcement territory.
I'm sorry, can I just ask you to take that again? You say that the language of ratify is different from enforcement. Now, obviously, the words are different.
No, sorry, no, my mistake. Assume that the statute says jurisdiction to enforce. I mean, ratify, enforce. That nothing turns on that particular point. My point is this, and I'm going to look at them in a little bit of detail. The cases that my learned friend refers to turn on the interpretation of a rule on service out of the jurisdiction, which uses the language, a claim is brought to enforce a judgment. And he's saying that judgments on that wording somehow have a bearing on the very different wording of Article 24(1). They do not. So he mounts an argument to say, well, a freezing order is not a claim to enforce a judgment. Well, that might avail him if you were dealing with a differently worded enforcement gateway. That is not what this gateway says. In my submission, if you just look at the simple language, jurisdiction to ratify does not exclude the possibility of interim relief in anticipation of the ratification or enforcement of the judgment. My learned friend seems to be saying that freezing injunctions haven't got anything to do with enforcement. And in my submission, that's absurd. They are, the purpose of the freezing orders, we know from Board Idea, is that they protect the future right to enforce. It's worth having a look at paragraph 94 of Board Idea, which is found at page 59. And he says here, well, you know, when you're enforcing a judgment at common law, you're bringing in action on the debt created by the judgment, and all that's true. To which I answer a resounding, so what? He says, the legate observes at the bottom of this page about the difference between bringing in action on the judgment and enforceable by registration. No reason in principle why this should affect the court's willingness to lend its assistance where needed by granting a freezing injunction to ensure that its process of enforcement will be effective when it's engaged. So therefore, the fact that when you have your judgment, can sue on it as creating a debt does not exclude the possibility that the court prior to that point has jurisdiction to grant relief that will prevent the frustration of the judgment. I say that it's not a strained construction of Article 24 to read it as extending to applications brought in support of the effective future enforcement of a judgment. And that the fallacy that you can only intervene when there's actually a judgment was rejected by the High Court in Bayan. But they said it's simply self-defeating to construe the court's powers as limited in that way. So I want to go really very quickly through the list of cases relied upon by my learned friend in support of his argument that you construe this as excluding a freezing order simply because it is not itself enforcement of a judgment. It's ancillary. And he said, well, that's fatal, he says. And he relies on a number of cases. And the Susquina, in my submission, nobody should be relying on the Susquina now. It's a save us for its construction of the rules. It's been overruled by the Privy Council, and it was decided in 1979, and things have moved on. Mercedes-Benz, if we could have a look at page 648 of the bundle. Yes, this is Lord Mustell. Now, again, I mean, he's articulating the proposition made out by my learned friend. It doesn't enforce anything. It merely prepares the ground for possible execution. It intended to hold the position until a judgment comes into existence. To which I say, yes, indeed. But why on earth would any of that fall outside the jurisdiction conferred by Article 24(1) of the court law? I mean, apart from the point I've just made, which is that the language of the rule that Lord Mustell is looking at is the claim not brought to enforce, which is different from the wording in our case. And then as for what Lord Nichols had to say, I mean, he just brushed aside the enforcement gateway because he was concentrating on the injunction gateway, which he thought applied. I mean, he was in the minority there. But he wasn't really interested. He just in a principled examination of whether the enforcement gateway would apply, because he thought the injunction gateway would apply. Now, my learned friend took you to the case of Masri number 4. That's a very different sort of case. It's concerned with witnesses. That case is about the examination of judgment debtors. Now, and when you have a company, obviously, there's not a person to examine. So there's a provision for to summon the officers to appear so that they can be examined. And the question was whether that rule is intended to be extraterritorial. So you can summon as witnesses directors who live abroad. And the court said no. And that's because they're witnesses. And the court is wary about exercising what you might call an exorbitant jurisdiction over people who don't even live at its jurisdiction, who are not parties. There's no doubt that it can summon a debtor who's abroad to answer questions in support of the enforcement of a judgment debt. So Masri is concerned with the court's policy about not bringing people who aren't even parties before them. Then we saw a Cayman case and a Jersey case. I mean, again, I don't think I can those particularly add anything, say that they are concerned with different wording. I mean, Cayman, Lord Justice Chadwick, Justice Chadwick said that it was for the Rules Committee, but that's not surprising when you've got two decisions. You've got a decision of the House of Lords and the decision of the Privy Council interpreting that rule. I mean, that's not the case that was confronting the Court of Appeal in Sandra Holding at all. They didn't have two massively authoritative decisions about the interpretation of rules of court. They were deciding the point as virgin territory, as it were. So that is a different sort of case. Broad Idea was not concerned with the enforcement gateway at all. So for my learned friend to rely upon that as somehow saying anything about the enforcement gateway is just, it's just beside the point. It had nothing to say. It was not relied upon against Dr. Cho. Who knows what the answer might have been had the point been taken. It wasn't. The territory was around the construction of the injunction gateway. And the articles referred to by my learned friend are off the mark. I mean, of course, he said, well, the decision on territorial jurisdiction in Broad Idea isn't criticised. Well, that's not what it's about. It's common ground. But then they weren't deciding anything on the enforcement gateway. So what? And as for Mr. Saranovic's criticism of the English system, well, the English rules of court are very expansive, actually. They, as my learned friend said, they constantly being expanded. to bigger and bigger classes of case. I mean, you know, and one could no doubt criticize the approach of the courts, but that's not what I'm asking this court to do. Now, Ark-Moldova, see, my learned friend is saying that Ark-Moldova has to stand. If we look at page 303, we'll see what they were actually asked to look at.
You've gone silent. Sullivan, you're on mute.
Sorry.
Yeah.
Yes. Okay. So sorry, it's 303. So in this case, the applicant, that's Justice Black, as counsel, was trying to persuade the court to lift the corporate veil and treat the yacht owning company, as the alter ego, or having no separate corporate personality from the defendant husband. And they said, no, we're not going to do that. And so you can see that. 21, they say to extend jurisdiction to a party against whom a judgment was not made on the basis that he possesses juridical although it possesses juridical personality, is to be equiparated with the party against whom judgment made, would be a significant development in the law. So that's what they're saying. They're saying, well, we're not going to, you know, ignore corporate personality and find that a judgment against individual A is a judgment against company B. Well, I mean, that's pretty orthodox, frankly. What this doesn't have is the benefit of the reasoning in broad idea about the non-cause of action defendant, which the point is they don't need to be a party to the judgment. They need to be holding assets, which are assets available for enforcement. And that was the conclusion which the Australian High Court reached earlier in Carlisle. Just if I take you to 908 of the bundle, where paragraph 57, the High Court simply summed up the position where you're looking for freezing orders against third parties. And you see, ultimately, either they're exercising a power of the judgment debtor or potential judgment debtor, or some process is or may be available to the judgment creditor as a consequence of the judgment against the actual potential judgment debtor. I mean, that's the test. It's irrelevant whether the third party is a party to the judgment. The question is, are the assets of the third party available for enforcement of the judgment against the defendant? Of course, that's a matter for evidence, and you'd have to persuade the court that there was a sufficiently good arguable case to get you a freezing order. But with the benefit of this analysis and that broad idea, I repeat, the Court of Appeal in Ark-Moldova would have reached a different stage. The law has moved on since Ark-Moldova was decided, and in particular, a broad idea has shown that their apparent limitation there, which was tempered by the fact that they were asked to lift a corporate veil, is not a genuine one. I have one final point, which is about the position in arbitration. Now, in arbitration, obviously, the jurisdiction of a court, for example, to enforce foreign awards, that is non-DIFC-seated arbitration awards, arises under the arbitration law. So this is only by broad analogy. But there is a recent decision of this court, in which I was on the losing side, which held that the court may enforce an interim award of an arbitral tribunal granting a freezing order. Of course, that is about arbitration and it's about enforcement of an award. It's not about the court exercising its own jurisdiction. But the court has taken a very broad, purposive approach to the construction of the arbitration law. And as I said in my skeleton, you end up now with this anomalous position, whereas if you're you can't come to the DIFC court and get an order recognizing, you can't get an order in support of foreign proceedings, but you can enforce an arbitration, an interim order of a arbitral tribunal, even a non-DIFC arbitral tribunal, where it's made in the form of an award. So that, in my submission, the direction taken by the Court of Appeal in the arbitration case denotes the direction in which the court needs to travel. inconsistently with the development of the IFC as a dispute for international dispute resolution. I won't go through the case, but it's called Neil and Nadir, and it is at page 442, and it is the leading decision was given by Justice Cook. Well, the entire decision was given by Justice Cook. I'll just check my notes. Oh, yes. Yes. So my final flourish is this. My learned friend has broad ideas diametrically opposed to my submissions. It absolutely is not. What it shows is the fundamental importance of the court having the power to grant relief in support of the prospective enforcement of a judgment, and to sort of nickel and dime it and say, oh well, it's just ancillary, or it's not a cause of action in itself. Doesn't take away from the fundamental fact that there is a right there to be protected, albeit the right has not yet crystallized. And that is the importance of the freezing order jurisdiction. Your Honour. Unless your Honours have any further questions for me, those would be my submissions.
It's Justice Gross. Justice Lemiere.
Nothing further, thank you.
No, thank you.
Can I just ask, though, if Justice French and Justice Lemiere, are we planning to stay on or have a separate link?
I think we can use the same pre-discussion link we used before. If the court officer, Lena, could perhaps confirm that to me.
Yes, of course, Your Honour. You can use the previous link.
Thank you so much. Well, thanks to both counsel for comprehensive submissions. Been very useful. It's an important case on a variety of fronts, and we're much assisted by what you've put to us. Thank you.
Thank you.
We'll now adjourn and reserve our decision.
Thank you.